All rise. The Justices of the Appellate Division, Supreme Court First Department. Hear ye, hear ye. All persons having business with the appellate in 1 year, give your attendance and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. We have some 6 hours of argument time requested, so please keep that in mind as I call the calendar and ask only for the time that you actually absolutely need to make your most important arguments. Understand that we have your briefs, we have the record, and we are familiar with the facts of your cases. So let's start with People versus Leroy Bundy. Are you the appellant or the respondent?
I'm responding if the appellant is arguing.
Okay, that's a submission. Giovacco versus Graham. I'm just going to ask you to keep your voice up, please. Okay, I'll give you 5, 2, and 5. Thank you. People versus Robert St. Kitts is submitted. Burgos Caba versus 587-91, third.
Respondent believes requests 5, and the plaintiff responds also 5.
Okay. 5 and 2, 5 and 4. Did I get that? Yes, thank you. Milan versus FSJ Realty Group. Five, 2, 4, and 4. Thank you. People versus Darrell Mason. Yeah. Six, 2, and 6. Thank you. That was 3 cases. Am I correct? Darrell Mason, People versus Lloyd McKenzie, and People versus Michael Wisdom, correct?
Your Honor, I'm only representing Mr. Mason. I believe there are other attorneys here representing
Okay, People versus Lloyd McKenzie.
Good afternoon, Your Honor. James Koussouris for Mr. Mackenzie. You would request 10 minutes for that.
Okay. 8 and 2 and 8. People versus Michael Wisdom is a stipulation that's withdrawn. Summit Development versus Hudson Meridian.
Hudson appellant requests 7-2. Respondent requests 4 minutes, Your Honor.
I didn't hear you, I'm sorry.
4 minutes.
5 and 2 and 4. Tycoon Construction versus New York City Housing Authority.
Appellant requests 5 and 2. Respondent requests 7 and 3.
5 and 2 and 5 and 2. 156 West 15th Street versus City of New York. It is really hard to hear because you don't have a microphone and you have the mask. So I'm going to ask that you speak up, please.
Sure. I'd like to reserve 5 minutes for my reply, 5 of my 15.
You said 5 and what?
I'd like to reserve 5 minutes for reply.
Respondent 3 minutes, Your Honor.
Okay. 5, 2, and 5. Chowdhury versus Starbucks. Okay, we'll take the submission. Thank you. Mesquite Creek versus Mars Wine.
For appellant, 7 and 3, Your Honor.
Respondent 6
5 and 2 and 5. HIA 2 versus BlackRock is submitted. Prechtel versus Train is submitted. New York Civil Liberties versus New York City Department of Corrections. There's one appeal here. Are you, okay.
For the respondent, cross-appellant, New York Civil Liberties Union, we request 6 and 2.
Okay, 6 and 2 and 6 and 2. Thank you. First case for argument is Giovacco versus Graham. Justice Rodriguez is recused from this case.
Good afternoon, Your Honors. May it please the Court. Andrew Fisher on behalf of Plaintiff Appellant. It is our contention that the motion court erred in 3 ways.
Well, counsel,
First-
let me start with asking you, what's your legal basis for finding that Drake had a legal duty with regard to the security at the Garden, where his only obligation under the contract with Live Nation was to perform as a performer, to give the concert?
Right, so what we're asking essentially is for this court to recognize a duty that hasn't explicitly been recognized by this court or this state previously, but follows from other legal duties that are held in similar circumstances, and from other legal duties that have been imposed upon performers in almost identical situations in other jurisdictions. So Defendant Drake is on stage and objects have been thrown throughout the concert for 3 hours during the time he's performing before plaintiff is injured. And so we are requesting that this court find that he had a duty to act based on the...
What's the duty, though? The contract, he has a contract with Live Nation, so he doesn't have a duty to a third party unless he's done something specifically to the third, to cause there to be an issue with the third party, launched an instrument of harm in some way, one of the Espinal factors.
Right, we would contest that outside of that contract, and also given the fact that his contract gave him the ability to withdraw if something happened, we would say that outside of a contract in a circumstance like the district court held in Cunningham, where there's a performer on stage and there's an apparent risk of harm to audience.
Cunningham was very distinguishable, though, counsel. Cunningham, Eminem, the performer, actually had in the contract a provision saying that he would stop performing if he had thought that there would be some, occurrence that was going to endanger people. Maybe I missed it, but please point to this contract between Live Nation and the performer where it had similar language. Is there one?
So on page, it's not identical, it's not one-to-one, but
I
on
read the
pages-
contract, that's why I'm asking the question. I want you to point to where it says that the performer has the obligation or the duty to stop performing in the face of something going on.
So on pages 423 and 425 of the record is where we're pulling that from. So on 423, it establishes that Live Nation had the duty to provide security at the premises. Now, they ultimately contracted with MSG to handle that, but between Live Nation and Drake, that was on defendant Live Nation. And on page 425, if Live Nation didn't perform any of its obligations under the contract, defendant Drake had the ability to withdraw from the contract.
So, just stopping you there, where that might further be distinguished from the Cunningham case. Was there anything in the record that would indicate that the foreseeability, that there was actually something happening that Drake was aware of, that he neglected to stop the contract? And then my second question too, I guess is just more along the lines. So are you expecting us now to change what is the law or the way we see these kind of contracts in New York State so that at any point in time, in any sporting event, any musical event where a crowd is rowdy, that the person who is performing or playing that sport can be held liable? Because that's what you're asking.
So addressing your second question first, Your Honor, we're not asking under any of those circumstances, but I think, one, where there's a concert performer like this who is aware, and I'll address that point as well, but who's aware of a foreseeable risk of harm, that they should have a duty to act also, given the fact that there's contract language indicating that this sort of condition may have been anticipated by the parties and adequate security not being provided. And now, as to Drake's actual awareness of this, we don't know, because as we addressed in our motion to compel his deposition, there's been no discovery, nothing from him to this point, and defendants have consistently tried to avoid producing him for a deposition or offering any alternative route to complete discovery, any statements, any affidavits, nothing. So there are tribal issues of fact as to his
So that would be, what you're asking us to do, as like my colleague says, is that we're really expanding the scope of liability. That means if I were to agree with you, where the contract in this case does not specifically say that the performer is obligated to do anything in terms of security, I mean, you can read what you want, but it doesn't say what you want it to say. That would mean that our decision, if we were to agree with you, would mean that every performer now, going forward from this day on, is subject to liability, regardless of what the contract says.
Your Honor, I see that my time is up, but if I could just briefly answer.
A brief answer. Is it?
So what we're asking here is really for a narrow finding, and if Your Honors agree with us in the reading of the contract language that it gave Drake the ability to withdraw, then it would be a more narrow holding than that concern and what defendants contest, and wouldn't apply to all defendants.
Thank you.
Thank you.
Good afternoon, Your Honor. May it please the court. My name is Steve Rosenfeld, and I represent all of the respondents.
So with regard to Drake and what we just heard from counsel, that the language that he wants to I guess, expand upon is that the performer should withdraw. In the contract, it says the performer could withdraw. How would that apply to Drake at this performance?
Your Honor, first of all, it assumes that there was, in fact, a foreseeable event or some kind of showing of specific harm. What the testimony was that there were cups and straws and some napkins and maybe some confetti-like things that were being thrown through the crowd that one might see at a concert. There was no indication that anything that was being thrown was harmful to anyone. The second thing I would say, and I must say this is probably outside the record, but if you've ever been on a stage and you have lights in your eye, you don't see anything, because all you see is the light.
But isn't that something we would need to hear from Drake himself through a deposition?
Well, Your Honor, under the circumstances, the court, in its discretion, in its exercise of discretion, granted the motions for summary judgment, notwithstanding the fact that Mr. Graham had not been deposed. In fact, there is nothing in the record before the court that indicates that this complaint that there was no deposition was even raised in the motion below. In fact, we moved for summary judgment, and the alternative, we moved for a protective order, and the further alternative for a confidentiality order. Appellant's opposition was limited to the motion for summary judgment. There was nothing in the record that opposed the motion for a protective order. There was nothing in the record that opposed the motion for a confidentiality order. So we take the position that the plaintiffs' appellants have waived this argument because they didn't raise it below. They may have raised it in discovery proceedings that are not part of the record, but the bottom line here is that there is nothing in this record that indicates that the motion for a protective order was untimely, because it was not, or was substantively deficient. So we take the position, Your Honor, that this is not properly before the court. It's raised for the first time in the appellate brief. And if we're going to be talking about things outside the brief, the plaintiff filed a note of issue. So discovery is closed. So, Your Honor, that is, I guess, my best answer. With respect to whether there is a duty here, Your Honor, and I know that you asked the counsel for the appellant with respect to Mr. Graham, just assume for a moment, just please, give me 2 seconds to say this. You're at a football game, and a wide receiver catches a touchdown pass, and he's in the end zone, and he's doing his dance, and he's exalting the crowd to cheer and scream by raising his arms up in the air, and maybe he does a backflip, and maybe he goes even further and, does some kind of display that's obnoxious. And then 2 fans get at it in the stands because they don't like what happened. And the fan of the opposing team punches somebody who's a fan of the celebrating athlete. Is the athlete responsible for what happened? Is he responsible for providing security, or she, if it's a sport involving women, if it's a soccer game or a women's basketball game? I think what we're doing is we're asking. I think what my opponent is asking for here is for the court to expand beyond anything that the courts have considered the duty and the obligations of performers and athletes who have not agreed in contract to provide security. The Cunningham case, which is a District of Columbia case, has a contract which is, and the actions are far distinguishable here. In that case, there were crowd crushers. There were other cases, the court, that the plaintiff has cited that there was mosh pits and crowd crushers, and in the Rotz case he cites, that was a crowd crush and people were running down the street, beating people up at a Diana Ross concert. The bottom line here is that nothing that is alleged to have happened here even comes close to that. And when you combine that with the absence of a contract and the fact that neither Drake nor Live Nation was obligated under contract to provide security, and in fact, Madison Square Garden, in an affidavit of one of its senior lawyers, Mr. Weidenfeld, acknowledged that they were responsible for security. Of course, he did not admit liability, but he acknowledged the responsibility. All of that says that there is no liability here at all with respect to Drake or Live Nation. Quite frankly, there's no liability with respect to anyone if you're going to look at the foreseeability arguments here, because this was not a foreseeable argument, a foreseeable event. Thank you very much.
Thank you.
Your Honors, with respect to foreseeability, the points the defendant's making are clearly distinguishable from this case. It's not, in the other case, there was a crowd crush or incident like that, but the question was foreseeability. It's not the severity necessarily of what's happening, but we would also say that here, objects being thrown throughout the arena, as ultimately happened, would indicate that there's a potential harm to the audience members if they're struck by something. Defendant also incorrectly stated what was being thrown. It wasn't napkins, it wasn't confetti. There were lighters, there were full cups of beer, and at least one metal beer bottle that struck my client and caused catastrophic
But the question
injuries.
about the duty remains the same.
So as to the foreseeability point that defendants brought up, and as to all defendants, where there's objects being thrown throughout the arena for a period of 3 hours, and there's questions in this record as to whether or not Drake was aware of that, summary judgment should be denied to determine the extent of his awareness, and this court should hold that performers, unlike a football player, a performer at a concert who has language in his contract indicating that he can withdraw if adequate security is not provided.
What's the difference there, a football player and someone at a concert? Both are providing some sort of entertainment. Both might in some way rile up the crowd or do something that the crowd does not necessarily like, probably even more so in a football game, right? They miss a catch, whatever the case may be. Are they responsible now for what's going on in the crowd, especially when that security detail has been put out to someone else?
I would say that that instance is distinguishable from this one, where it's an individual performer on stage and there's language in his contract giving him the ability to withdraw. A football player would be different. As to the protective order, defendant's incorrect as to his timeline of what happened. There were multiple discovery orders over a period of 13 months for demanding or directing that the deposition take place. Defendant ignored all those. In conversations with lower court counsel, only ever requested that the deposition not take place, and their motion for a protective order was deficient on its face because there was the affirmation of good faith was incomplete and didn't provide the proper information. Thank you.
Thank you. Thank you both. Burgos Cava versus 587-91, third owner.
Good afternoon, Your Honors. Kevin Pollack from Fabiani Cohen Hall on behalf of the appellants. It's submitted that the court below should be reversed and that the plaintiff's complaint should be dismissed, as well as an awarding of contractual indemnity against the plaintiff's employer, OV Painting.
Counsel, this is a case where they're going down the stairs with a painting machine that is quite heavy, and one of the plaintiff falls backwards down the floor. How is that not a runner case?
Well,
And why isn't this case one where there should have been a device?
Well, I would beg to differ with you in terms that it was quite heavy. There's disagreement in terms of the weight.
Well, let's say it was 70 pounds or whatever.
Leaving aside...
Whatever it was, his supervisor thought it was weighty and cumbersome enough in terms of its width and height and to require someone to help go down the stairs and enlisted him to do that. So they're going down the stairs.
To answer your, I apologize. To answer your question about Runner, Runner has nothing to do with this case. Runner was a case involving a falling object, which fell as it was going downstairs, and it dragged the plaintiff into the real. You don't have that here. There's no falling object case. The plaintiff fell.
Well, I mean,
because he misstepped.
since Runner, we've found liability under 240 sub 1 in other areas where there is no fallen object, maybe something is on the same level. I think the issue here is, was a safety device provided? What safety device was provided?
It's our position that device was not necessary. I don't think the plaintiff made the burden of proving that it was in his motion. In terms of our motion, I think we did with the expert. If you're assuming that 240 does apply to this case, which we don't concede, if you want to start there, then the elevator was provided as a device to use. In fact, the plaintiff and his foreman were standing in front of...
time. It wasn't available.
I'm sorry?
The elevator was not available.
Well, the elevator was there. It's just that they decided not to wait for it. You couldn't be any more available since the plaintiff and his foreman were standing in front of it, waiting for it.
And it never came. And that's why that's why the foreman decided to go down the stairs with the machine.
It didn't come because they decided to leave after as little as 10 minutes.
Did the foreman even have the means to contact someone? Did he have the device, the walkie-talkie or whatever it was, to be able to contact the elevator operator? I don't believe so.
He did not have a walkie-talkie. He was aware of the procedure.
So he could have been waiting for Godot standing at the elevator if he had no means to get in touch with the operator.
I haven't heard that expression in a very long time, but...
I haven't seen the play in a very long time either. But.
I don't think he would have been waiting for Godot, because Godot never showed up. I think, he took the elevator the day before, brought the painter up, was aware of the procedure. He also said that his procedure was to stand, again, I don't think it's very clear with the exact configuration of the elevator door in the elevator, but he said as the elevator would come and pass, he would be able to signal to the operator that he needed the elevator. So
But this was a freight elevator or a passenger elevator? Does it make a difference?
I think these were just two, I don't think anyone called them passenger or freight. They were just two elevators, one was designated, I think, for passengers, and one was designated to bring materials. I don't know.
But one also was not working correctly?
There's an abundance of evidence that it was working. The plaintiff claimed it wasn't. There's witnesses who said it was working. We have an affidavit from Mr. DiMartino who said it was working.
At the end of the day, it was not the plaintiff's choice to take this machine down the stairs. It was his foreman that instructed him, help me take this down the stairs. You go first, I go behind you, and that's how he fell.
And that's a perfect segue to why we should have been awarded contractual indemnity, which I'll get to in 1 second. At the very least, given the conflict in the record in terms of everything from one expert versus another expert, minutia about buttons, minutia about weight. I think at the very least, the judge should have denied everybody's motion, say it's a question of fact for a jury to decide if under these facts a safety device was necessary. In terms of your point, yes, that's why the court below should have granted us contractual indemnity against the employer. The judge denied it, saying there's an issue of fact as to apportionment. Well, that's why the judge, if he felt that, which we don't think is even an issue of that, but if he did, he should have awarded conditional contractual indemnity, which he didn't. For the first time on appeal now, the employer argues that there's an issue of fact whether or not the defendants were the sole cause of the accident, which they did not argue below. They just said there's an issue of fact as to negligence. And we submit that based upon the facts, there is no issue of fact here regarding whether or not the defendants were the sole cause of the accident, which this court said would be grounds for denying contractual indemnity is premature, but you don't have that here. Here, there's no issue of the defendants being the sole cause of the accident. As you just said, the plaintiff's foreman directed the plaintiff to walk down the stairs backwards. That's clearly a basis for contractual indemnity. We submit unconditional, at the very least conditional.
Thank you.
May it please the court, I'm Steve Arapach from Barry McTiernan and Moore for third-party defendant, respondent, OV Painting on the indemnification issue. I would first like to point out that the contract required defendants to provide a material hoist, which OV could use, and it says, under supervision of CM Associates. So they were actually supervising the method that created the hazard. And although counsel claims that there is no issue regarding whether this was hazardous, their own witness, Matthew Pabon, testified that he deemed it extremely hazardous for people to carry materials on the stairway. And after the accident, he gave all kinds of instructions about, I'm sorry, I think I can take this off actually by the rules. Thank you. He gave instructions about no matter how long it takes, from now on, you can wait for the elevator. He also acknowledged that there was no way for someone on the floor to use the call buttons to summon the elevator, because with the elevators were turned to operator control, and that disabled the call buttons on the floors. So the foremans were supposed to be issued two-way radios so that they could summon the elevator. However, plaintiff's foreman did not have that. Plaintiff's foreman thought the only way to summon the elevator was by standing there and banging as it went past, which, as you have pointed out, did not summon the elevator for a half hour. So the elevator was not actually made available for plaintiff, and as a result, plaintiff was injured. And since OV was not provided the means to use it, and it was CM Associates' duty to provide that, there's an issue of fact, at least, as to whether CM was negligent and whether, and it was properly, defendants were properly denied contractual indemnification.
Thank you.
Thank you.
May it please the court, Jason Richmond on behalf of the plaintiff respondent. I'd like to open my argument here by asking to revise the amount of time that I require, as the court has stolen all of my points and thunder. I have very little to add. Runner is exactly applicable. Moving a heavy object down interior stairs in the absence of any kind of a safety device. The plaintiff and runner utilized an ad hoc hoist Here, the plaintiff was directed to use a per manus hoist, using his hands and those of his supervisor. He had no choice in what to do. And this is the exact circumstance in Runner. It's the exact circumstance that this course has previously found labor law to apply in its Conlon decision, cited in my brief, cited also in the defendant's brief, the appellant's brief. Working on a staircase, hauling a heavy thing down a staircase, both hands on the heavy thing, walking backwards, is definitely a circumstance where a fall is foreseeable. That said, I take no position with respect to the issue of indemnification, but even after the accident, plaintiff's foreman was never provided with a two-way radio, was never provided with any other means of summoning the elevator. He didn't have one there that day, and the requirement is not that the law commands a general contractor or an owner to provide a safety device. That's not what the law says. The law says to provide, place, construct, and operate. All of those things are co-equal requirements under the labor law. This elevation-related safety device, if an elevator even counts, was not present at the plaintiff's workstation, was not available to him, and he was directed by his foreman not to use it. There's simply no question of fact here. And with respect to the idea that there are conflicting expert affidavits, there aren't. The defendant's expert never renders any opinion with respect to a machine which, according to its manufacturer's specification, which are judicially noticeable, weighs 105 pounds. I've got nothing else to add unless there's a question.
Thank you very much.
Just quickly, in terms of the assertions by OV's counsel, it's just untrue, simply untrue. They make two assertions in their brief that the defense witness acknowledged that it was hazardous and dangerous for workers to do things. That's just blatantly untrue. There's no such testimony in the record. I urge you to look at the cited pages. It doesn't exist. It's just not true. Another thing in terms of everything that they wasn't done allegedly in terms of a radio, this or that, that's not negligence. This was a 100% means and methods case. The defendants did not direct or control anything in terms of the procedure they used at that moment. The foreman told the plaintiff to do it. Therefore, the defendants weren't negligent. These other things they say that should have been done, if anything, are maybe general supervisory things.
Well, they had control they had the ability to stop the work or to suggest another means.
But this was means and methods. The issue is whether or not the defendants actually supervised, directed, and controlled the activity, the injury-producing activity, which they didn't. So there's no negligence on the part of the defendants. Another thing is that in terms of 241-6, the plaintiffs never opposed dismissal of that, so they abandoned that, and that claim should have been dismissed since they didn't oppose dismissal of it. And last but not least, in terms of Runner, one thing quick, the accident was not the failure of providing a safety device. Again, the plaintiff fell because...
So when someone has a heavy device and they're asked to walk backwards down the steps and they're holding on to the heavy device, they don't need, it's not foreseeable that they could catapult down the stairs?
But that's not what happened here. What they were carrying had nothing to do with him falling. He clearly testified the only reason why he fell was that...
If you have a heavy object and you're holding on to it and you can't see the stairs, that seems like there's a built-in cause right there.
Your hands are occupied. There's no way for you to hang on to the
Banister?
The banister.
Thank you.
Thank you. Thank you all.
Right.
Milan versus FSJ Realty Group.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant, respondent. On my appeal, our position is that the trial court erred in granting summary judgment to the defendant under 240 subsection 1, 241 subsection 6, and denying plaintiff's motion on the same claims. In this case, as you know, there was a pound, 10-foot-long hose that fell from the second floor to the ground.
Well, I think it was thrown there, but whatever. It went down to the
Right.
ground, yes.
And whether it was deliberately thrown or dropped, I mean, there's a series of cases from this court, starting with Diaz against Rava, to Pados against City of New York, to Albuquerque against City of New York.
So what do you have to demonstrate to be entitled to a 240 sub 1? To be in,
But my burden is to demonstrate that the defendant's failure to provide an adequate safety device was
and what would that
proximate
have
cause.
been here?
And, I'm sorry?
What would that have been here?
A pulley, a rope, a hoist, something. I mean, our expert lays that out at 774 of the record, that nothing was provided to protect a worker that's below. There was, it's open, superstructure that's open, and there's a ladder from which the workers go up and down and bring the hoses down. And I think that's what's really...
There was no other kind of overhead protection in that area, that work area,
No,
was
and
there?
in fact, if you look at the 301 of the record, I'm sorry, it's hang on a second, 365 of the record. Wayne Richards, who's the project manager for FSJ, that's the owner, he was asked, this is really important, I'd like to read this. So how would the hose normally come off the slab? And they're talking about removing it. Commonly, is it thrown but not on people? No, you would never throw it down. That's not the proper procedure. You know, you would never throw it from any level. If you're going to do something like that, you have someone downstairs giving you the okay, drop it or something like that. You mobilize the area, you section it off, you say keep away, you rope it off. Would you ever, but you'd never lower it on a hoist or a rope. And the answer was, well, even so, you still need someone downstairs to guide it. And then
Well,
the question...
Counsel, we've read the record, but let me just ask you this question. Does it matter that plaintiff didn't know what hit him or didn't witness the accident coming himself? And in fact, most of what we have here is hearsay things put together?
No, because circumstantial evidence, as this court has held, actually could be even better. In Caraballo, this court held circumstantial evidence could be better where it's not disputed than direct evidence, for example. And here you have Mr. Richards, who, by the way, I was going to say at 365 of the record, admitted that no types of pulley or device was ever provided at the site. But he goes to the site within probably minutes or seconds after he falls, and he sees the pictures are at 981 of the record, and he sees the plaintiff sitting down with his foot injured, and he sees the hose right next to him. And then he says that workers told me the hose fell on him. So, and then the S&S worker admitted to him, yeah, I dropped it. So, I mean, all of the circumstantial evidence is the only evidence before the court, and it was never disputed by the defendant. So, to answer your question is, in this case, circumstantial evidence is as good, if not better, than direct evidence. And it's not been disputed that no safety devices were provided to protect the worker who's below an area where the hoses are brought up and down, and the plaintiff actually sees the hose hanging. As he's coming down the staircase, he sees the hose hanging. So the fact that he does, and this has been held by, I still have a couple seconds, in the Pados case, which Judge Renwick, you sat on, it actually, this is what that they said. You said that in terms of circumstantial evidence, a piece of rebar fell from 30 feet above, striking the plaintiff. In moving for summary judgment in his Labor Law 240 claim, plaintiff was not required to show the exact circumstances of how the rebar came to strike him, as his testimony that a coworker was working with rebar 30 feet above him on the same column immediately before the accident was sufficient evidence that the rebar, whether it was dropped or fell in some other manner, was material required securing for the purposes of the undertaking. So here...
That's with regard to the 240 sub 1.
Correct. Yes. So to answer your question is, in this example, it was circumstantial evidence, and summary judgment was granted in Pados against City of New York and other cases too. One last thing I'd like to read to you, just because you affirmed the Supreme Court...
I think you're going to have to read it on rebuttal.
Okay. Thank you.
Yes.
Good afternoon, Lisa DeLindsay for Respondent Appellant S&S Concrete Pumping. And as for my position on my appeal, I rest on my brief, and I will be addressing the court as a respondent today. I think what is clear to understand here is that the plaintiff was not working at the time the accident happened. He had climbed down the ladder, he was on the ground. There's black
Was he
letter
on the
law.
ground, or was he on his way down the ladder
He was
to
on the ground.
Mhm.
Testimony was on the ground, and it's black letter law all over all the departments that it has to be a foreseeable risk of the task that the plaintiff was performing.
What was the plaintiff performing before he got off of the ladder?
Before that, he was engaged with using that cement hose with his other workers, applying the cement ceiling. They had
So that's
complete-
why he's there on that construction site, because he's involved in pouring the concrete and he's walking down, coming down.
Yes, but that task was completed, they were done for the day.
But how,
Go ahead.
he had to climb down the ladder in order to leave for the day, right? So, I mean, he can't magically just transport himself someplace else, right?
No.
Okay.
Yeah. But again, this is why it's a deliberate dropping case. The protections of labor law are very.
But that's if there's a dropping zone. There's no dropping zone here. This was not an area that was sort of cleared or expected to be a dropping
No,
zone.
but all of the cases I cited to, none of those were a dropping zone. They were somebody throwing something off of a roof. And, Mr. Richards' testimony is about what he perceives to be safe. He's not a labor law expert. He can't testify as to the provisions of the law that really clearly delineate what has to be found to get this ordinary protection. Just because something falls on you does not necessarily mean you're protected. And I believe the lower court was correct in finding that this was a deliberate dropping case. And I'm adding that it was unforeseeable that this was going to happen. And had it been foreseeable, that would be a different story. But if it's deliberate dropping, it's unforeseeable.
So you're saying because the worker that is above decides to throw something below, and the plaintiff who is just ending his day happens to be there as he's leaving and gets struck by it, he's out of luck.
That sounds like ordinary negligence to me, and not the specific protections of labor law, which if the plaintiff is granted that, he gets interest from the day of the decision.
Okay.
That's negligence. That's not labor law protection.
Does it have to do with the fact that someone threw it, or does it have to do with the fact that he has just ended his workday?
I think it's actually both. Had he been still up on the second floor, engaged in...
Counsel, he's on the work site. He's on the work site, he's working. I think you ought to use a different argument than that he just came down the ladder and he's no longer working.
Again,
I don't think that's your best.
Yeah, I think that's ordinary negligence of somebody doing something they shouldn't have done, as opposed to, had there been something in place. My person wasn't there, he wasn't using the hose, he was there disassembling it, putting it back on the truck. And it wasn't being used at the time of the incident. If there are no further questions, I rest on my brief. Thank you.
Good afternoon, Your Honors. I represent Vartel and FSJ, who were let out of this case, and I believe this was properly done. A few points I want to make from what plaintiff said. To start off with, plaintiff starts out saying, oh, it's uncontested that absolutely this was 150 pounds. This was not 150 pounds. This was not, first of all, plaintiff didn't see what had dropped on him. And
But FSJ's witness testified that what in fact the item was.
He testified that something had dropped, but it wasn't that his 150-pound, there was testimony from S&S that talked about it, that this was not.
So you're saying that it wasn't heavy enough?
From talking about it, it was.
It was enough to knock him to the ground.
This is, okay, if you get to that point from their evidence that he knew that this was what had
He wasn't knocked unconscious, I don't believe.
No.
So then he was aware that he was knocked to the ground.
In the testimony, the evidence that he provided he provided his first deposition, and he said, I don't know. But my other point I
Well,
wanted to get to.
someone else knew. There were
Well, this is
eyewitnesses
what
who
we.
knew and who was spoken to right away.
Afterward was then our employee, Mr. Richards, and that's where you get the business record information from. But I wanted to be a little, to explain a little bit about my understanding about what that worker who deliberately dropped it was actually doing. He was, he had to declamp this smaller piece from the larger piece, and there was a routine that was set up for him doing that, and it was supposed to have been that he would do it just close to the ground, okay, and that would be where and it would not, something like this would not have fallen had he done it in the proper
Isn't that exactly
mechanism.
why there are devices? Because things don't always go the way they are expected to go, so there's a device to prevent from that.
But this was not not a safety device in the sense of Labor Law 240. This was that was an apparatus that was used to help to spread the concrete.
I understand. It was a tube-like structure that was spreading the concrete. They took it away, and they were taking it apart, and they had to have a means to get it out. They didn't get that far because it fell down and hit someone to the ground, knocked someone to the ground. So there was no device to allow them, or a rack or something, to allow them to safely place this very long, cumbersome, heavy tube while they dismantled the whole thing.
Well, the mechanism was to have, for the individual to have moved it lower so that the piece could be, it could be unclamped from it. So what he did something that was not what the proper mechanism was for taking care of that. So it was a deliberate act, and so the cases that the plaintiff cites were all are not appropriate to this to the case. Anyway, so I will rest on my papers.
Just two quick things. There's every every witness testified that the hose was either 80 pounds, 150 pounds, regardless, it was heavy enough when that it falls from a floor above, that it comes within the ambit of 240 and entitles plaintiff to summary judgment. What I wanted to, and with respect to what my adversary just said, if the SNS employee improperly disconnected the hose or dropped it, under either scenario, it still is a 240 subsection 1 liability on the part of the defendant, because it just reinforces that the hose was improperly secured for purposes of the undertaking. What I wanted to read quickly was what the trial court said in Albuquerque, only because you affirmed it, and I think it's very apropos here. The trial court said the following in Albuquerque against City of New York. Defendant's argument that 240 does not apply to objects that are intentionally dropped is dead wrong. By defendant's reasoning, a construction site would be a free-for-all with tools and timbers and beams and kitchen sinks raining down, and anyone injured on the ground below is out of luck. I think that's very apropos here. One thing I'd just like to finish on, I'm going to skip 241.6. It's in my brief, 1.7A1. I feel at the very least there's a question of fact, but if you grant me summary judgment on 240 subsection 1, it's rendered academic. With regard to me being a respondent as to SNS on 200, the court properly awarded plaintiff summary judgment on 200 under the means and methods, but I think that the court erroneously granted summary judgment to SNS on plaintiff's labor law 240 subsection 1 and 241 subsection 6. As you know, under Royland against McGovern.
Did you oppose that motion by SNS before Supreme Court?
Yes, we opposed. SNS moved on all of our claims, and we opposed on everything.
Including summary judgment?
On 241 and 241.6. We did oppose on that. We didn't move for summary judgment against them on those, but we opposed their dismissal of those claims. And as you know, a subcontractor has liability under 240 and 241.6 if it controls the method of the work. Here, not only did it control the work, it actually created the hazard by admittedly dropping the hose. So I think the court got it right by granting summary judgment to plaintiff as vis-a-vis SNS on 200, but erroneously dismissed 240 and 241-6 on SNS's motion. And if you have no further questions, I'll rest on my brief.
Thank you.
Thank you very much.
Thank you all.
Thank you.
People versus Darrell Mason.
Good afternoon, Your Honor. May it please the court, my name is Stephen Preziosi, and I represent Mr. Darrell Mason. Your Honor, the acts for which Mr. Mason was convicted in California are the same acts for which he was tried and convicted here in New York under counts 5 and 6. Your Honor, an important part of my brief is the statutory double jeopardy component, not just the U.S. constitutional double jeopardy or New York State constitutional double jeopardy, but the statutory double jeopardy component of this, which is broader and all-embracive of New York State's constitutional
Well, counsel,
double
let me
jeopardy
ask you
concept.
about those, his convictions in California. How essential were they to a conviction for conspiracy? Because a conviction for conspiracy really only requires the proof beyond a reasonable doubt of one overt act of the co-conspirators. So why isn't that separate? Because here, that's at least what the jury found.
So, Your Honor, there in those laundry list of 96 overt acts, there are only 2 overt acts with regards to Darrell Mason. Overt act number 61 and overt act number 96. Overt act 61 was the allegation that Mr. Mason had sold 5 kilos of cocaine to Brandon Woodard, the unfortunately person who was murdered. There is no evidence other than the allegation that my client made a statement that he was sending this cocaine to New York with Brandon Woodard. And if you read the statement, the NYPD narcotics officer and the DEA agent are heckling and trying to coax my client into saying that he was sold this cocaine so it could be transported to New York. But he balks at that. He says, no, I hate New York. I don't know how he hired me, but he says, I hate New York. I would never do that to New York. I would never have any association with New York. I hate it. That's overt act number 61. The remaining overt act with regard to my client is overt act number 96. The exact acts for which he was convicted in California, and I made a motion, and I provided the court with all of the transcripts from the California trial. And I go through it in my brief. I compare the statutes in California to the New York statutes for which he was convicted. I compare the testimony. The testimony is identical from the California trial to the New York trial. The transcript is identical. The evidence is identical. The witnesses are identical. And Judge, just if I may, I'm not going to read it. I'll try and paraphrase.
Let me just ask you this question. Was this argument to dismiss the indictment based upon this this double jeopardy, was that raised below? Because it's part of your ineffective assistance of counsel claim, right?
My double jeopardy argument is under the framework of ineffective assistance of counsel.
Was there a 440 motion that raised that below?
No, Your Honor.
Okay, so how is it properly before us then at this juncture?
Because it's part of the record, Your Honor, or its absence is glaring on the record, Your Honor. When a fundamental constitutional issue is not raised in the court below, it may be raised here as part of ineffective assistance of counsel. I think the absence of his argument of this constitutional
I guess the question is really whether it is clear on the record. That is the issue. Because if it's not, it really is properly at a 440 hearing.
It is clear, and here's why, Your Honor. It is clear because at the Molyneux-Sandoval hearing, they tried to raise his conviction in California. They wanted to raise that on their case in chief. And everyone said, no, you can't raise it. It's exactly the same conviction as what happened here. Everybody recognized it was the same conviction, but nobody raised the double jeopardy issue, either constitutional or statutory. Judge, I would like to touch upon point 2 of my brief, the Batson challenge. During jury selection,
Batson has already been decided, hasn't it? I mean, didn't we already have the appeal of another individual where the Batson, very, very, very same Batson?
and here's why this panel should decide differently, Your Honor. Yes, Your Honor is correct.
Well,
Here's why this panel should decide differently. Because
we tend to follow the precedent of the case where the exact same facts are
here's the issue
before the court.
If I may, Your Honor, here's the issue that was not addressed by the previous panel, is that whether or not that was the issue and was raised by the people below, is whether or not someone who belongs to 2 protected classes is protected by the Equal Protections Clause under Batson. These were both African American and females. The people struck 8 of them, 7 by peremptory challenge, and it was the disparate treatment of these potential jurors that was never addressed as being part of 2 protected classes that was never addressed by the previous panel. Your Honor, if I may just very quickly go through some of the examples of what happened in the court below. Your Honor, the people struck 3 African-American females because they were unemployed or underemployed. There were 4 white people who were unemployed who were not struck. That is disparate treatment, Your Honor, and that shows that their reasons for perempting those jurors, the African-American females, was pretextual. They also perempted an African-American female, Miss Ashley, because of her associations. Her boyfriend was a parole officer, and according to the people, parole officers have relationships with parolees and people who are convicted. They did not strike Miss Powell, a white woman whose brother was a public defender who would have those same types of associations. That is disparate treatment. There are other...
Thank you. I'll let you finish if you have anything else on rebuttal.
Thank you, Your Honor.
Yes.
Good afternoon. May it please the court. Vincent Revelisi for the people. I just wanted to clear up one thing on the double jeopardy. When a defendant is charged with a single substantive crime and then later is charged with conspiracy, the single substantive crime can still be proven at the conspiracy trial. It's the other way around that would be a problem. If he had been convicted of conspiracy first, he wouldn't be able to be charged with a substantive crime that would have been subsumed within the conspiracy. So that's the misunderstanding here. And of course, as for the Batson claim, it was already decided by this court, and it was found that there was no purposeful discrimination. Unless there are any other questions from Your Honors, I'll rest on the brief for this defendant.
Thank you.
Thank you.
Your Honor, just getting back to the previous panel's decision, Your Honor, there are, as it was argued in the court below, there are no decisions to determining that when one of our fellow citizens belongs to 2 protected classes, are they still protected by Batson? That was their argument. That was their initial argument. They said, okay, if it was just African Americans or just females, that would be protected by Batson. Their argument was because they belong to 2 classes, that does not fall under the Equal Protections Clause of the 14th Amendment or the Equal Protections Clause of Article 1, Section 11 of the New York State Constitution.
Now, these are the same 7 jurors that were challenged by the prosecution, and this is the same argument that was made in the other trial. And we've already found that as to those 7 jurors, that the prosecutor gave race and gender-neutral reasons for all the challenges. So you're saying that now we should look at it again and find otherwise?
Yes. Yes, because there was no finding, and there are no appellate findings, and I'm hoping this court will address the fact that we have fellow citizens that belong to 2 protected classes. That was the argument below. And that was what the court said, okay, they belong to 2 protected classes, Batson doesn't apply. So, Judge, I just want to touch on this point 4 of my brief, the PowerPoint issue. The people said their PowerPoint was just a summary of the evidence. I disagree. I strongly disagree. What the witness did was took testimony that had already been heard by the jurors, and evidence, documents, videos, photographs, bank statements, a whole series of evidence, and compared the two and said to the jurors, look at this testimony and look at this exhibit, and here's what you should conclude. Like a syllogism, when two things are compared and a new idea is proffered, that's new evidence. That's opinion evidence. And this was a lay witness. If there are no further questions, I'll rest on my brief, Your Honor.
Thank you. Thank you both. People versus Lloyd McKenzie.
Good afternoon, Your Honors. May it please the Court. My name is James Kasouris, and I am here on behalf of Lloyd McKenzie. Your Honors, in our appeal, it is our position that there is a confluence of events and holdings that require a new trial. What I'll focus on in this short period, and primarily our first point, is what I have referred to as this phone-it-in procedure that was concocted after Mr. Tauger was rendered rather helpless and completely debilitated from his injury. That devolved into what became ineffective assistance of counsel during Mr. Tauger's summation and during the jury deliberations and the prosecutor's summation when he could not voice timely objections. And then that leads into, after 35 years, I don't remember seeing prosecutorial remarks as I saw in this case, which may have come from...
You're talking about the summation.
Sorry?
You're talking about the summation.
The prosecutor's summation.
I don't know that those things were preserved. I looked at them myself, but I didn't see objections to them, for the most part.
I'm glad you raised that, Your Honor, because in this regard, the people are trying to have it both ways. No, some of them weren't preserved because the man couldn't hear them. And the next day, when
But there was someone else in the courtroom.
Your Honor, Judge, you can't just fill a chair.
No, I believe that the person who was in the courtroom was a supervisor or had one point supervised the other attorney. So this was a seasoned attorney, and the kinds of things that were being said were not so much substantive as they were hyperbolic and, other kinds of statements that one would recognize and be able to object to. So I don't know.
Well, that as well can be put within the rubric of ineffective assistance of counsel. Mr. Tauger is not able to hear the prosecutor's summation. He doesn't object. But I completely agree with you, Your Honor. And under Ashwell and its progeny, in so many cases that this court and other departments have held, when prosecutors say things like that, it can be reviewed in the interest of justice, first of all, under 470, but clearly as ineffective assistance. You're right. This, I don't know the man, but this was his supervisor at legal aid, a seasoned attorney. And when you hear prosecutors literally saying the things that were said about Mr. Tauger, the personal attacks, you can't trust anything he says. He's like Donald Trump. And
Well, counsel, as I began, the majority of these were not preserved, and if you feel that they were ineffective, then that's a 440 that I don't see was had here.
Well, Your Honor, and that's why I started my argument by basically saying you really need to take all of this together, because I believe, respectfully, that when you look at this record, this court has before it more than enough to find ineffective assistance of counsel for not objecting. But if I can go to our first point, because I think it is so important, the procedure that was followed here, first of all, was not a legal procedure. It should not have been sanctioned. Both the court and the prosecutor made it very clear that once Mr. Tauger was completely unable to attend, he couldn't be physically present.
Counsel, I'm wondering, you know, as I recall, sometimes there might have been trials where an attorney might replace someone for a summation or to take a verdict or something like that. Why is this any different than that?
Your Honor, this was a case in which, as you've heard before, there were over 70 witnesses. This was a 2-month trial, and counsel, there's no question we're talking about a critical phase of the proceedings. I think I've heard of counsel sitting in during deliberations, maybe, when counsel had to start another trial. Not that I'm in favor of it, but here you're talking about first giving a summation which was palpably deficient in the first place, and second, counsel not being there during a prosecutor's summation. Counsel needs to be there during a prosecutor's summation because he was there for 2 months.
Had there been any arrangement for Mr. Talbot to communicate with his client during the prosecutor's summation?
Well, that was a problem, Judge, because no, there was no mechanism for the client to actually communicate with his counsel. The way it happened was there was a phone-it-in where he's supposed to be on the phone, and I think we've
But
made
they tested this, I'm sorry, but they tested this the day before or the day of, and everything was fine. The people had purchased some sort of speakerphone, and counsel said that he could hear everything fine, tested out the speakerphone, it was very sensitive, everybody could hear him.
Your Honor.
And then at the summation, the next day, there seemed to be an indication that he couldn't hear. It wasn't that very day during the summation when he couldn't hear. Was anybody saying, I can't hear? I don't understand.
Mr. Tauger, I can't hear the court, but I can hear you. Could you speak a little louder? The court, Tauger is indicating he can't quite hear clearly what's being said. Tauger, I can hardly hear the court. Tauger, Your Honor, I can't hear a word you're saying. I'm sorry. The court, the afternoon in his summation, despite Mr. Tauger's difficulty in hearing. Tauger, I can't hear a word that the prosecutor is saying while he's speaking. Tauger.
Was this on the day of the summation? This is not July 21st.
These run, Judge, from 3741 of the transcript to 4272. They are throughout the proceedings. And then, you know, the next day.
Throughout the proceedings, we're talking about the summation here.
The proceedings we're talking about. But the next day, Mr. Tauger makes it abundantly clear, I couldn't hear the summation. I had to read it and then lodged what the people are now claiming are untimely objections because he couldn't hear it. Your Honors, we just spent all of this time going through the pandemic. And we cite Section 180 just as an example here of what we all went through. I was on how many virtual hearings where you needed the consent of the parties. Mr. McKenzie realized what was going on. He withdrew his consent, and he did it rather eloquently, and he is more well within his rights to do that. If during any virtual appearance that we have encountered over the pandemic, courts were so clear.
Did Mr. Tauger join in Mr. McKenzie's motion?
I'm sorry, sir.
Did Mr. Tauger and Sandeman adopt a motion that was made by Mr. McKenzie for a mistrial?
No, they didn't.
Why not?
Why not? The real point here, Judge, is if we're on a virtual hearing and a defendant says, I no longer consent, nobody needs to agree. And why they didn't say anything, I don't know, but there is something so powerful.
Oh, that's why we need a 440. Thank you. You have rebuttal, of course. Once.
Your Honors, there's one particular page that's very telling in Mr. Tauger's.
Counsel, why isn't it, I can't hear? I can't hear the judge, I can't hear the prosecutor. Why isn't that? That's a problem.
Yes, when he did say that, that's when they would change the situation. They would move the phone, the judge would speak louder. When those situations where Tauger could not hear, something was done. He never said that he missed what needed to be heard. And in fact, there was one time, and I wanted to point this out in particular, on pages 4214 to 4215, when Tauger said, "What's happening?" because he didn't hear anything. And one attorney was showing another attorney a case on an iPad, and he was told of that, and he said, "Okay, that's why I didn't hear anything." So that really expresses that he knew that he was listening to the proceedings. and that he
Counsel, could it be that because this trial had gone on for days, 70 witnesses, that at that point, the court was more concerned with judicial economy, so to speak, than the defendant's rights?
Well, I think that's the first thing the court said when this was raised, was that it mattered what the defendant thought about this, and they had a conversation with the defendant before agreeing to this, and he said it was what he wanted. He was very affirmative about that's what he wanted.
Well, he wanted that when he heard when they were first doing the test.
Yes.
And the test was clear.
Yes.
But then during the summation, which wasn't just a 2-minute test, it became unclear.
Every time that it became unclear, though, something was done to address that, and Tauger did not actually say that he couldn't hear the summation. He said that he had to concentrate hard to hear every word, but he did say that he heard it. He didn't say it was easy, and I understand that that's not ideal. Obviously, he'd be better in the courtroom, but he did say that he heard it. He just had to concentrate very hard.
What about your adversary's position that once the defendant withdrew consent, that's it, that should have been the end of it?
Well, because he had an attorney in the courtroom as well, and also, if you gave him that entitlement to be able to call the mistrial at any moment, it would really just be the rest of the trial. The defendant could at any moment decide he didn't like how it was going and say, "I want a mistrial." The much better way to view it would be to consider it ineffective assistance of counsel claim. Was he receiving effective assistance? Otherwise, it would have been up to the defendant at any moment for the rest of the trial automatically to just say, "I want a mistrial." The whole point of having him agree to this procedure in the first place, he was agreeing to a particular way of being
I think
represented.
that part of the problem here is that we're sort of now taking a look after the fact as to whether counsel was actually able to hear. And why don't we just take him at his word? He couldn't hear.
Well, he didn't say
You're pointing to points in the record where it says that there was silence. They were looking at an iPad. That's why counsel couldn't hear, because in fact nothing was being said. That's challenging his position that he was having a tough time hearing.
But that's why you would need a 44010, because then you could actually have the attorney explain what he missed at the trial, that there were times that he couldn't hear anything.
How does one put forward what they missed when they didn't hear it?
Well, he would say that he would testify that I was there and I couldn't hear things and I wasn't
He said that.
But he didn't say he didn't hear things after they corrected it.
He didn't say what he didn't hear. That's crazy.
He didn't say that he didn't hear things and then when it was corrected that he still couldn't hear. Every time there was a problem, you can see there are many times in the record where he says, "I can't hear," but then something's done about it.
What about, were any, and I'm going to ask you the same question I asked counsel, what arrangements were made if Mr. Mackenzie wanted to talk to his attorney, to Mr. Talbot?
So Mr. Tauger and Mr. Sandeman were in touch by cell phone, and the defendant was obviously sitting next to Mr. Sandeman in the courtroom. And there was some discussion about how when Sandeman would text Tauger, the defendant complained he had to wait for Tauger to text back. But of course, that's the only way to text. But that was the lifeline between defendant and Tauger so that all three of them could communicate, including privately by the cell phone texting. So there was that arrangement, which was separate from the phone arrangement, which was public for everybody to hear.
And do you think that arrangement was satisfactory? Does that give the defendant the right to counsel when the defendant has to wait, and whatever the issue may have been, the ship may have sailed by that point?
Well, it wasn't ideal. Obviously, it was not ideal, but it was acceptable to the defendant. He accepted that arrangement.
Right, but then as it progressed and he saw it happening in real time, it became unacceptable, right?
He said that it did, but his attorneys didn't adopt that, which again would be a good reason to do a 440 if that's the case. But the reason, if you look at the record, the time that the defendant made this motion was right after the complaints about the prosecutor's summation. So it actually looked like it was piggybacking on what was happening about the arguments about the summation. And he did say that he wasn't able to get responses right away, but there was no indication that the judge refused to allow them to communicate at all. That if they had asked for any amount of time to wait for a response from Tauger, they didn't ever ask for that and have it denied them. So there was nothing on the record that says that they weren't able to communicate in the way that they needed to communicate, and that would probably be why Tauger and Sandeman didn't adopt the motion. It would really make sense to do a 440 if this was a real problem that actually existed, when you can't see it in this record.
Is that it?
All right, unless there are any other questions, I'll rest on the brief.
Thank you.
Very, very briefly, this notion that were you to honor my client's withdrawal of his consent, that would give a license to other defendants to just stand up at any time during the trial and say, I want a mistrial, and get it. That's not so.
Counsel, I guess that's not really my concern. I guess my concern is without the 440 motion, how do we address this ineffective assistance? And then what does that mean for moving forward?
Your Honor, thank you. My answer to that is you don't need it, because this procedure in and of itself, as was just questioned by the court, should not have happened. In response to your question—
It shouldn't have happened.
Of
But
course not.
someone breaks his leg, and then everybody agrees it's going to work. And then as it unfolds, it's not ideal by any stretch of the imagination. But you are asking us to accept what is on the record, and from that, find that this was ineffective or declare a mistrial. And it's impossible with so many places where an attorney is saying, okay, I can't hear, okay, then you fix it, okay, then you go forward, and there are objections to some things, not to others, to understand fully why that is done. I understand all of the issues here, but 440 is truly the only way to resolve this, it seems.
Your Honor, I understand your point. I obviously feel that this record in and of itself is sufficient. I just do want to say that on this record, you know that my client was not talking to his lawyer. And the Constitution requires more than texting and phone tag. It just does in order to do this. I just want to raise one.
Go ahead.
I can still go, right?
You only have 39, but I'll be flexible.
I appreciate that. There's an issue we haven't talked about that really, I respectfully submit, warrants a reversal. You don't give a jury an indictment. And I understand more, but I also will tell you that you know that every other case, from the statute 330 to all the cases that have followed, have made it so abundantly clear you don't give the jury an indictment. Moore was 2 felony murder counts. They were just read word for word. And for some reason, the Court of Appeals said, we'll make an exception, it's harmless here. You're talking about an indictment that contained dozens upon dozens of overt acts, and a court speculating, and this is important, the court simply speculating, well, maybe they just wanted to do a vertical analysis, or maybe they wanted to do something else. The appropriate thing to do under our jurisprudence is to bring the jury in, find out, clarify what they're looking for, and not speculate before you violate a statute, and quite frankly, violate decades of jurisprudence, except for one very distinguishable case. And the remedy is that it is reversible error. So I would ask the court, perhaps look at that as well. And thank you for a few additional minutes. Have a good day, Your Honors.
Thank you. Thank you both. Summit Development versus Hudson Meridian.
May it please the court, Chris Georgioulis for the appellate Hudson Meridian. This court, by its decision of October 2021, unanimously found that Hudson did not breach by withholding payment on requisitions 21 and 23 to Summit. And that was as a matter of law, because all you needed
Counsel,
to do—
I have to stop you. This case was, you're right, it was decided, and then it was, the order directed that there be some amendments. It was sent to the Supreme Court, and it was adjusted. The judgment was adjusted. What is the basis of your being here? Why is this appealable?
Because a judgment is always appealable. This judgment came after.
That is not true.
Well,
You had an order here, and you sought to appeal this order to the Court of Appeals. That was possible. You could do that. Then you could make a re-argument motion here. You can do that. But barring that, once this order is done, and it's just ministerial for what goes back, and it's followed, what's the basis to appeal that judgment?
It wasn't ministerial. That's the whole point.
It was ministerial. I was on the panel. It required subtraction, addition, application of various interests.
I disagree, and there was a decision of this court prior with regard to that $400,000 settlement. The court did not admit that settlement for reasons under 4547. It was a settlement agreement. So the court said, if I admit this agreement, then I have to take testimony as to who gets the funds, because Summit didn't do the work. It's contractors, it's subcontractors did the work. And in fact, Your Honor, you were on a panel in 2009 on a case of...
In 2009, you want me to remember the case?
No, I'm going to tell you the case, because it's on point. In that case, you among the other judges found that if you include in your lien funds that are due a subcontractor that you have not paid, that is a willfully exaggerated lien. In this particular case, the lien, this court, in its decision of October, said that this lien was filed prematurely, and Hudson then had a right to withhold. In fact, the court, in its decision at page...
Counsel, what we did was, with regard to the first issue, I believe, we vacated Summit's recovery on the payment of requisitions 21 and 23, and we reduced Summit's award because we said that they didn't breach, Hudson didn't breach the subcontract because the payment wasn't yet due to the
Correct.
So we corrected that on both of those.
But Judge, once that lien is filed for $1.5 million, of which almost $1 million was willfully exaggerated, it stopped all payments to Hudson, the owner. In fact, the court said at...
Counsel, did you appeal this decision to the Court of Appeals?
No, because I'm appealing this judgment first here, because this court found...
You had the right to appeal the decision, the order. You had a right to appeal that order to the Court of Appeals.
I have a right to appeal to this court the judgment.
You had, it's my question.
Sure.
Who you? You had a right to appeal our October order. Did you do that to the Court of Appeals?
No. I have a right to appeal this judgment, though, because you said, this court said we had a right to withhold. If we had a right to withhold, you need a predicate for interest. And that's a huge amount of money here. CPLR 5001A says, in order to assess interest, you have to have a breach of contract. This court said we didn't breach. And then $2 million was being held by the owner because of the inflated, willfully exaggerated lien. In fact, this court, previous to that, in July of the same year, we made a motion to strike references to the amount and the terms of the settlement. And this court granted that motion. So we have a settlement agreement that's not in the record, yet there's $400,000 outstanding or sitting there with no record to determine what has to be done, which means the trial court, as it said in its colloquy, and I've pointed it out in the briefs, said that we need to take evidence as to where this money should go.
Thank you, counsel.
Can I?
Thank you.
Oh,
You have rebuttal. I gave you rebuttal, so you'll come back.
I didn't realize my time was up, Your Honor. I'm sorry.
May it please the court, John Master Pietro for respondent.
I have a quick question. Did they move to re-argue and for leave to Court of Appeals?
Yes.
And it was denied by us, correct?
Yes.
Okay.
I stood here September.
And that's a final order. That's it.
Yes.
That's the end of that.
This is such an abuse of this process. I stood here in September of 21, and we argued a substantial appeal and cross appeal. The decision came out 3 weeks later in October.
We're
Hudson-
aware of it, counsel. We're
Hudson
aware of
Meridian
it.
filed a 500-page motion to re-argue for leave, introducing new evidence in November. In December, they filed a motion to stay the judgment. What we're hearing now is the fourth time for these issues before this court. The original appeal, this was all done in the motion to re-argue. It was all
Just
done.
to short circuit it, since you're going through what I think we already know the record, your position is this is a non-appealable judgment. Is that right?
Correct. It was a ministerial act to send it back.
What I said?
Yes, 100%.
Okay.
These arguments are before this court for the fourth time. My client needs closure. This is a case that's been litigated for 14 years. They cut and paste certain arguments that have already been before this court and rejected. The idea about no breach, the requisition 24 was the breach. They didn't turn over the retainage. It's the fourth time it's been before this court. This court has determined these issues. The idea that there's no interest due. Judge Cohen awarded 9%. This court, on one requisition, increased it from 9 to 12% under the Prompt Payment Act. The brief before this court now makes the assertion that this court vacated the award of interest. There's just no good faith basis for that. Hudson Meridian Appellant continues to argue that this fund, the $360,000, somehow had to go back to the Supreme Court for an allocation of who was due what. That's not what this court said. And by the way, I've got a subcontractor who's been waiting as patiently as my client that's going to get a cut of this money once this thing is resolved. There's no basis to these arguments that have been raised here today. If there are no further questions to this court, I rest.
Thank you.
Thank you.
CPLR 5701 allows an appeal from a judgment. That's a matter of right. It's a substantial right that Hudson enjoys and has a right to appeal to this court because it's not a ministerial act. If it was, the court would have directed.
Here's what 5701 says. It provides that an appeal can be taken to this court as of right in an action originating in the IAS court from any final or interlocutory judgment, except one entered subsequent to an order of the appellate division, which disposes of all issues in the action. That would be the October 22 order, where we disposed of all of the issues in the action. So there is no, pursuant to 5701, a right to come here on this judgment.
I disagree with the court because again, back to that settlement agreement, there is nothing in the record with regard to that settlement agreement. And this court, previous to that October decision, said, hey, all references to amount and settlement terms are basically redacted. So how can anybody then argue that that $400,000 belongs to someone when there's no record in the trial at all with regard to that amount of money? There's got to be some testimony. In fact, the trial court said, if I admit this settlement agreement, I have to take further testimony as to who gets the money. Because don't forget, Hudson had a assignment from Interstate, which was the subcontractor that owed Hudson money. We paid a $300,000 claim on behalf of Interstate. Where'd do that money? This wasn't a final
Thank you
order.
very much, counsel. Appreciate your time. Thank you both. Tycoon Construction versus New York City Housing Authority.
Good afternoon, Your Honors. May it please the Court, Adam Perlin behalf of Plaintiff Appellant Respondent, Tycoon Construction Corporation. This case is about the New York City Housing Authority's refusal to pay a contractor for extra work and declare claims despite a timely notice of claim.
Counsel, I have to ask you, so you think there's a timely notice of claim?
I do.
Okay, because I was going to, what's the basis of your wrongful termination when NYCHA had the ability to terminate for any reason? So, okay, it's your...
Yes, and we believe that, regard to the extra work, that the notice of claim was timely because no claim accrued until NYCHA, the Housing Authority, denied the list of costs Tycoon submitted on January 11th.
So with regard to your, the extra work and the delay of work, you had to give 20 days, right? 20-day
Correct.
notice of claim.
From the accrual of the claim.
Okay. Was that first one filed more than 20 days after the claim? I think you, plaintiff, you alleged that it was filed on January 11th?
Correct.
2017?
The notice of claim was filed January 11th. That's correct, Your Honor. And if you look at the contract, Section 31 of the contract, it's at the record at page 249, provides that a voucher, invoice, or other routine request for payment that is not in dispute when it is submitted is not a claim. If you take a look at the record, the Housing Authority issued design changes throughout the month of October, October 20th, October 21st, and October 31st. On December 27th, my client, Tycoon, the appellant, submitted its list of costs, assuming that it would be paid. On January 11th, the Housing Authority denied that claim. That was the first formal indication that the Housing Authority was not going to be paying the extra work that my client did. And then the notice of claim was filed the very same day. So there's no question that it was filed within 20 days of the accrual of a claim. Under the contract, there's nothing in the record to indicate that the Housing Authority ever told Tycoon prior to that date that it was not going to pay for those costs. And what's very bizarre is that the lower court chose the earliest date possible. They chose October 20th as the date that the claim accrued, when there's allegations in the complaint supported by an affidavit that say that the changes were made on October 20th, October 21st, and October 31st. Yet the lower court chose the earliest possible date for the accrual of the claim. And again, under the contract, the claim actually did not accrue until January 11th. Section 31 of the contract makes that clear. Even if the court disagrees with that, the EEC case is directly on point. And it says that even if the court finds that it accrued prior to that January 11th denial, it did not arise, the claim did not accrue until damages were ascertainable. Here, damages were not ascertainable until December 27th, when my client submitted an invoice, a list of costs. If you take a look at the record, if you take a look at the totality of this case, we have a matter where the Housing Authority, at the 11th hour, comes up with massive design changes that require 11 out of the 17, 14 out of the 17 entrances that Tycoon had already done to be redone.
Let me ask you, if you are wrong on the notice of claim, that is a condition precedent to your suit, is that right?
Yes.
So if you are wrong about the notice of claim, what would the result be?
If the claim is untimely, then the claim would fail. But we don't believe that that's the case here. We believe that the notice of claim is timely both regarding the extra work and regarding the delay claim. And again, just on the extra work, right, we believe that in the totality of the circumstances, given the facts here, and it is a fact-dependent analysis, that it was reasonable for Tycoon to wait to see if there were going to be additional changes to find out what its damages were.
On the delay claim, doesn't the contract say that the sole remedy is extra time, not anything else? what is it that you're seeking then? If
I see my time is up, but if I could answer Your Honor's question.
Yes.
So that's regarding the damages for delay, and there are exceptions when there's a no damages for delay clause. And we believe that we've both met the timeliness and that we've met the exceptions, the Corinna Savetta exceptions here. Those are set forth in our brief, and if there are no further questions, I have
Thank
time
you.
for rebuttal as well. Thank you, Your Honors.
Good afternoon. May it please the court, Karen Cross for New York City Housing Authority. Having correctly dismissed appellant's claim for extra work and project delays as waived or barred under the contract, the lower court erred in allowing appellant to revive these very same claims simply by recasting them as termination for convenience costs. The lower court correctly held that appellant waived its claims for delay damages and extra work by failing to file its January 11th, 2017 notice of claim within 20 days of the claim arising, which was a condition precedent to recovery. Appellant's extra work claims arose when its damages were ascertainable at the earliest on October 20th, 2016, when NYCHA issued the order to do the extra work, or at the latest on December 19th, 2016, when appellant claims to have completed the extra work. In either case, more than 20 days prior to submission of the notice of claim. Appellant's delay damages were ascertainable when the last of the delay periods ended on December 16th, 2016. Again, more than 20 days prior to submission of the notice of claim. The lower court also correctly held that the delay claims were barred under the no damages for delay provision. The record indicates that the extra work and delay claims asserted in the notice of claim are identical in all respects to the extra work and delay claims asserted in the claim for termination for convenience costs. Those documents appear at pages 829 to 895 and 1140 to 1206 in the record. The court's decision deeming these extra work and delay claims on the one hand contractually barred or waived is not only inconsistent with the holding that they're somehow meritorious on the other hand, but they're also inconsistent with numerous holdings of this court, which require a contractor to strictly comply with the notice of claim provisions, serving the basic public policy interests of putting a public agency on notice of any potential liabilities. In allowing this decision to stand, it sets up a scenario where a contractor can simply avoid the consequences of failing to comply with Section 32 by renaming their claims as something else and asserting them as a separate cause of action. The lower court's decision is also inconsistent with the basic contract law premise that the different clauses of a contract should be construed harmoniously to give each its intended effect. NYCHA asserts that this argument regarding duplicativeness is properly before the court, as it concerns a determinative legal argument raised by virtue of the lower court's decision as to whether an appellant can revive a claim that's waived or dismissed. And it's fully supported by this record. As stated previously, the documentary evidence irrefutably shows that the extra work and delay claims are identical in all respects. Moreover, this is not the first time that NYCHA has raised this argument. In its letter dated May 10th, 2019, NYCHA expressly denied the claim for termination for convenience costs, specifically because it was duplicative of the extra work and delay claims that were cited in the notice of claim. Finally, the lower court erred in failing to consider at all NYCHA's argument that appellant waived the claim for termination for convenience costs because it failed to provide the documents NYCHA requested under Section 32, which was also a condition precedent to recovery. Appellant largely failed and refused to produce the documents requested, objecting to, I think, a third of NYCHA's document requests as beyond the scope of the contract. And the court failed to weigh in as to whether this production satisfied Section 32's condition precedent to provide all of the documents required under the contract as a matter of law. And for those reasons, we feel that the lower court decision should be reversed.
Thank you.
If the court has no further questions.
Thank you.
So again, I think the Housing Authority misstates the issue. You know, they're arguing that the notice of claim was submitted more than 20 days after the accrual. But again, Section 31 of the contract says that a routine request for payment, which this was, were design changes, the client submitted a list of costs, and then it was denied on January 11th. That's when the dispute arose under Section 31 of the contract. That's when the claim accrued. And within 20 days of that was when they were required to submit their notice of claim. It was submitted the very same day, therefore the notice of claim is timely. On the cross appeal that the Housing Authority has filed, the argument that the claims are duplicative was not raised below, and the argument is not preserved. It also necessarily involves factual determinations that are better left to the normal course of discovery. What the NYCHA is asking this court to do is to basically conduct an analysis of the claim in the underlying action, not the underlying action, in the termination of a cost convenience claim that was submitted in the course of the contract, which, as counsel alluded to, was denied on May 2019, and asking the court to compare that to a cause of action here, determine that they're duplicative, and dismiss the cause of action. The lower court was correct not to do that. It's something that, as the facts are revealed through the course of discovery, if it does reveal that there's duplication, the court can deal with it then. It's inappropriate on a motion to dismiss. If the court has no further questions, we'll rest on our papers.
Thank you.
Thank you.
Yes, thank you. I respectfully disagree with opposing counsel. The issue of whether appellant provided the documents requested to NYCHA is a question of law, because it's a condition precedent to recovery on the claim. Second, I think that opposing counsel misstates the holdings, the precedent in this jurisdiction set forth by this court on numerous occasions, as well as the Court of Appeals, stating that a cause of action arises and a claim accrues when damages are ascertainable. On this record, appellant's extra work claims were ascertainable based upon several documents appellant had submitted to NYCHA, including a schedule contained in the notice of claim, appearing at, I believe, pages 1172 to 5 of the record. Thank you.
Thank you. Thank you both. (156) West 15th Street versus the City of New York.
May it please the court, good afternoon. My name is Kent Gubrud. I represent the appellant, 156 West 15th Street, Chelsea, LLC in this case. We are appealing the decision from an Article 78 proceeding, which upheld the supposed lawfulness of 2 oath administrative decisions against petitioner, which we have combined for this appeal. Both administrative law judges, ALJs, refused to allow petitioner to adjudicate our many constitutional objections, including due process, to New York City's charges and proceedings. We appealed both of these oath decisions.
Counselor, you talk about due process, but you were provided, your client was provided notice of the violations, yes?
Yeah, it's not in dispute.
And notice of the hearing and an opportunity to be heard before oath at a hearing.
Yes, but not a meaningful opportunity.
Okay. Go ahead.
Okay, thank you. In fact, due process requires New York City to conduct its oath hearings under applicable law and requires its ALJs to adjudicate the arguments and objections of its litigants.
There was an opportunity to present witnesses. I think they presented witnesses. Is that right? Or testimony that established?
Theoretically, yes.
That your client had temporary people in the apartments?
Well, no. It actually
They were using it as an Airbnb. In other words, they were using, that your client was using several of the apartments as an Airbnb apartment, which is illegal in New York.
The tenant of my client, not my tenant, not my client. He's the owner of the property.
Right.
New York City has held them vicariously liable for the actions of their tenants.
Owners aren't allowed to, that is not permitted in a New York City building. So the owners are vicariously liable for whatever is happening.
Well, that's the argument of the city, yes.
My point goes to your argument that there wasn't due process. I'm saying you had an opportunity to cross-examine witnesses, to be heard on all of those issues. That's what I'm saying.
Well, not given the reality of how the city prosecutes these cases, because it does not involve my client. The witnesses weren't disclosed. The witnesses is simply an inspector from the city who testifies to hearsay about what other people told him. So we are surprised to find out what the city's case is when you show up for your hearing. That's how they operate in Manhattan, at least.
The notice of the violation, does that, or the complaint rather, doesn't that serve as a purpose?
I'm sorry, I couldn't understand you.
The notice of the violation, the complaint rather, how does that affect the proceedings? Do they need to do anything beyond put in?
How does the notice of violation affect the arguments?
The proceedings at oath, right?
Proceedings? Well, this is actually quite complicated, because what the city does is a notice of violations mention violations or they claim that a residential unit becomes a hotel. And so what they cite are hotel violations in the summons. And they're not applicable to this type of residency. And so there's a whole series of problems with what goes on here. And that's why we tried to narrow it down to this one issue, because there are literally hundreds of potential problems with what the city does here.
Aren't they alleging that the apartment is actually being used in that
I'm sorry, I couldn't understand what you said.
Isn't the city alleging that the apartment is actually being used as a hotel?
Isn't the city...
Transient use.
I'm sorry, isn't the city
alleging that the building is being used with transients, for transient use? The apartments are
yes,
being used
the city is.
for transient
The city claims that any use of any unit in the city for less than 30 days converts it into a hotel automatically, even though that violates the certificate of occupancy.
But they got that information from the tenants and from the people that were in the apartment.
What about the
investigator
information?
went, knocked on the door, and spoke to folks in the apartments, and they told them exactly what they were doing there. We are renting here for a couple of days. We're renting here for a week.
You know, the thing is, we never hear from these witnesses.
Well, see, well, hold on. This brings me back to the point that I tried to make earlier on in terms of what the summons having served as prima facie evidence of the violations. You could have called a witness on your own behalf, right? But you didn't do that.
Well, number one, we couldn't call because it wasn't disclosed to us who these people were. This is the owner who had nothing to do with the rentals.
But you could have called the inspector.
Sorry?
You could have called the inspector.
We actually tried to call the inspector who had been subpoenaed for the hearing and was present that day.
Yes, in the building.
The city refused. They objected to it, and the ALJ refused to let us question him.
You're talking about Inspector Rosado?
Yes, John Rosado. If you look in the decision, it discusses it extensively. We asked to question him. The city lawyer said no. And the hearings referee said, okay, I'm not going to let him testify.
You also could have called your own tenants, correct?
Yes, but my tenant had nothing to do with the rentals. He had no relevant testimony.
Well, what do you mean?
Sorry?
The tenant didn't know that his place was being used as an Airbnb?
No. He had leased the apartments to a tenant, and the tenant was doing these rentals. My client is a medical doctor who lives and works in Jamaica and is over an hour drive
Right,
away.
so one would presume that your client, right, your client's tenants, the ones that he leased the apartments to, would have information as to whether those apartments were being used as Airbnbs, and you failed to call your own tenant.
We were not, okay. It doesn't even matter. Okay, we assumed for the sake of our argument that this was used as an Airbnb rental. That doesn't, that fact, and we assumed for the sake of argument.
You're conceding the violation.
Sorry?
So you conceded the violation.
We're not conceding, we're conceding that under the city's interpretations of law, there were violations.
Okay, and just one clarification with regard to Rosado, you hadn't subpoenaed Rosado, so that's why the court didn't permit you to call Rosado, because
The city, the prior hearing
hadn't
had
been
been
subpoenaed.
adjourned for the city to subpoena him to appear. He did appear, but then the city.
They decided not to call him, and because you hadn't subpoenaed him, that's why.
No, that's not why, but that's the facts are accurate. The city made a special appearance because I was there. They wanted to prevent me from questioning this witness, and therefore they said they're not going to call it, and they objected to my calling the witness who was physically present in the building to testify that day.
Okay, thank you. I've let you go well over the time.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of Respondent City.
I want to start where we just left off. Is it reasonable if a witness, an important witness, has been subpoenaed and the party presenting the case decides not to call that witness, but the witness is there? If the other party wants to call the witness, is there a reason to deny that? I'm speaking with regard to Inspector Rosado. Is that reasonable? Does that make sense?
Your Honor, I don't think there would be a reason to deny that, but that's not what happened here, as you
so what
recited from
happened?
the record. In this case, we decided not to go forward with our case in chief requiring Inspector Rosado. At no point in time did petitioner represented by counsel decide to move for an adjournment or actually subpoena Rosado. And each side, I think, got an adjournment once in each of the
That's
two
what I'm
proceedings.
speaking to. Rosado was right there, right?
That's right.
He'd already, so why couldn't he just take the stand? Why did he have to be subpoenaed when he was already subpoenaed by the other party to be there? He was
I
there.
suppose he could have taken the stand if petitioner had asked for his attendance. Petitioner did not.
Okay, let me just make sure I'm clear. You're all in the building. You're all in the room. Rosado is in the building and everybody knows it. And respondent says, I'd like to call Rosado. And the answer is no, because he hadn't previously subpoenaed him. Is that what you're telling me?
That is what I'm telling you, but I have another answer in response to
Okay,
your
so
question.
that is what I started off with, and that is what I asked. Was that reasonable under the circumstances? I mean, if you're really seeking due process, rather than allow this thing to go on, wouldn't it just be better to put the individual on and question and cross-examine or whatever?
I certainly see your point, but
I'm glad you do.
There was ample opportunity to cross-examine the inspector in the first hearing, and the only objections that petitioner's counsel lodged were repeated objections to hearsay. There is no articulation.
These are different violations at the second hearing, right?
That's right. That's right.
So what happened at the first hearing, what does that have to do with the second hearing?
I think my point is it's a lack of proffer, that at no point in time, at any point of the record or this proceeding, has petitioner articulated what it is that would have helped them either with, articulate their substantive constitutional arguments or defend against the challenges here. And I think Justice Renwick has this.
Examination would be the defense against the challenge, right? That's his opportunity to try to do that. But if he's not allowed to even call the witness who is in the building, as my colleagues have pointed out, then where is the due process in that?
I just still want to push back on the not allowed, that a counseled party doesn't understand the rules of a tribunal and make certain strategic decisions.
Let's just cut to the chase. So what you're saying is that it's permissible to refuse to bring the inspector in, despite the fact that he's in the building, simply because procedurally, the party didn't subpoena the witness, despite the fact that the witness is there.
Provided that there's sufficient evidence in the violations, which there is here and they're not contested, and if there's any other basis that the petitioner can articulate or respondent in those proceedings can articulate as to why their testimony is needed.
Isn't it enough to put them to the test as to why they issued the violations?
I disagree, Your Honor, because I think
Then what's the purpose of these hearings then? I don't understand, right? If you can't question the witness or challenge whatever, the inspector or challenge why he issued the violation, then what's really the purpose?
There's a difference between you can and you didn't. And here they didn't, and they could have.
Well, God help a pro se before any one of the hearing officers, because this
I think we
person
would be in
was
a different situation. Your Honor. You're
represented
correct.
by counsel. Thank you.
Thank you.
So I apologize. I guess my hearing is worse than I thought. I have trouble hearing a lot of what he said. But as far as, if I understood correctly, there's a difference between that whether we could question this witness or whether we did. This, if he is suggesting that we refused or failed to try to question this witness, that is absolutely unsupported by the record. The transcript, we spent lots of time discussing this. In our view, it violates not only due process, but our right to confront the witnesses. The city called no witnesses in this case, not one. The city's lawyer submitted.
I understood his comment that there were two proceedings, right? There were two administrative proceedings. There were two administrative proceedings going on?
That's correct.
Right, and that the first administrative proceeding, the inspector, and maybe I've got this all mixed up, but the Rosado was at the first proceeding? He was not?
That was a different inspector
It was a
altogether.
different
That was
inspector, okay.
Vladimir Pugash.
Okay.
Who testified, and we had 2 days of hearings in that
And you had
case.
opportunity to cross him and all that and all that issue, yes?
Yes, we did.
Okay, got it.
But
I
the court,
just wanted to make sure.
the ALJ refused to accept our motions to dismiss, refused to allow us to adjudicate any of our due process and other constitutional arguments.
But you were not given an opportunity to interview Rosado, despite the fact you were not given an opportunity to question
No,
the investigator in the second set of summonses,
that's correct.
despite the fact that he was there and despite the fact that you requested to question that investigator.
Strenuously. We had substantial discussions about this with the ALJ, and she was going to allow it, and then she said no because the city lawyer objected to it. And so, and then the city not only, they offered his affidavit from a court case, and then they submitted photographs and other I see I'm done. Can I finish my response or question?
Sentence.
So they submitted the documents, photographs and hearsay statements taken at the location from the individuals who were in the apartments. And so we had now double hearsay. We had documents admitted without a witness to authenticate them. And there was no evidence that this witness that they're testifying about was reliable. So the hearsay was not reliable, double hearsay, and it wasn't allowed. A due process violation, right of confrontation violation. In your court Wolf decision, you said that
Thank you, counsel. If you could wrap up your thought now.
Okay, I'm just finished with that. If the Wolf decision talks about how we're supposed to have the same protections as a criminal case, none of that happens at the ECB in oath. None of it.
Thank you.
Thank you.
Thank you both. Mesquite Creek versus Mars Wind, sorry. Could be. be wind, could be wind.
Good afternoon. May it please the court. Elizabeth Bauer, Wilkie Fire and Gallagher, on behalf of Appellant Mesquite Creek Wind, LLC, who I will refer to as MCW. This appeal arises out of the Supreme Court's order partially dismissing MCW's claim for a breach of a guarantee provided by Appellee Mars, Inc. Going into the argument on Mars's motion to dismiss, there was only one issue in dispute between the parties. Both sides had agreed that the guarantee provided by Mars extended to the obligations under the PPA, which was the guaranteed document, in the original form and as amended or modified.
Can I ask you, why would you be entitled to a guarantee under the risk mitigation agreement where the only reference about a guarantee is in the power purchase guarantee, and the risk mitigation agreement doesn't make any reference to a guarantee?
Because, Your Honor, the PBRMA, the Production and Basis Risk Mitigation Agreement, is an amendment or modification of the PPA, and the guarantee extends to any amended obligations. Here would be the obligations under the PBRMA.
But doesn't the RMA, the risk mitigation agreement, change the obligations of Mars Wind in terms of the excess, the hedged energy excess? Right? It's not necessarily, making it a new document as opposed to an amendment.
It is a separate document, Your Honor, but it modifies the obligations that the parties had agreed to under the PPA. And it does so because the excess energy under the PPA is calculated on an hourly basis. About a year into the parties' agreement, Mars, Inc. Expressed the concern that Mars Wind was purchasing too much excess energy under the PPA. And the way Mars presented it, it was because of that hourly assessment as opposed to calculating the amount of excess energy to be purchased by Mars Wind on a monthly basis.
Also, I guess what it really boils down to here is whether this was a new agreement, a new responsibility versus an amendment.
That is correct, Your Honor. That is the issue that the parties had gone into the motion to dismiss to argue. However, that's not the issue that Justice Borak decided. He decided that regardless of whether it was an amendment or a new agreement, the guarantee only extended to the original document, not to any amendments or modifications. And our position is the guarantee applies to the guaranteed document in its original form and as amended or modified, and that the Production and Basis Risk Mitigation Agreement amended Mars Wind's obligations pursuant to the PPA.
Does it extend to a new agreement? Does it extend to a new responsibility?
The guarantee would not necessarily extend to a new agreement. However, the PBRMA is not a new agreement. It is an amendment or modification of the PPA because it effectively reduced the amount of excess energy that Mars Wind was required to purchase. And it reallocated the profit that MCW was eligible to receive and did receive when it had to go into the market to cover production shortfalls in the event that it didn't meet the hedged energy amount that it was required to provide to BP. MCW had to go into the market and acquire that energy. And at the time that this was happening, the purchase price in the market was often lower than the contractual price at which BP paid MCW. That was $33.17. Market price was often less. And Mars Wind complained that MCW was making too much money with that profit. And the PBRMA reallocated that profit and provided that profit in the event that the cover price of that shortfall was below the $33.50 in the PPA, that Mars Wind was now eligible to receive that profit. That not only modified how excess energy was to be calculated under the PPA on an hourly basis, but also modified and was in contrast with and contradicted Section 3.5 in the PPA, which said that Mars Wind was not entitled to any of that profit. It's explicit in Section 3.5 that profit was for the benefit only of MCW. And so the PBRMA affected both.
There was another document, a loss risk agreement, reimbursement agreement. How does that play into all of this?
Yes, Your Honor, there's a loss reimbursement agreement that comes into effect at the end of the parties' 20-year relationship. And it provides that if over the course of the life of these transactions, and there's a series of transactions that span this 20-year period, starting with the PPA and the guarantee as modified in the PBRMA, when the PPA expired in June of 2022, that kicked in an agreement called a CFD. At the conclusion of the CFD in 2035, the parties look at how much money has exchanged hands over this period of 20 years, and if it exceeds a certain threshold, I think it's 48 million, it's somewhere between 48 million and $50 million, then Mars Wind may be eligible for reimbursement of some of that amount of money. But that LRA comes into effect down the road.
Can I ask my question?
Sure, yes.
So I guess my question is just go into Section 6 of the Risk Management Agreement and then Amendment 1 of the Risk Management Agreement, where Section 6 of that RMA says that that is the entire understanding of this concerning the subject matter. And then the amendment references the LRA specifically, but it doesn't reference the PRA at all. So how are we to look at that in terms of whether or not the RMA was a new agreement as opposed to just an extension of the PRA?
You have to look at the effect that the production and basis risk mitigation agreement had on the PPA. Under New York law, you look at the effect, and if the effect is to change the terms of the prior agreement, it is considered an amendment. Thank you.
Thank you.
May it please the court, Ben Graham from Williams & Connolly on behalf of Respondent. Your Honors, I'd like to start right where that conversation.
Can I ask, where does this language in the guarantee fit into this entire discussion? This line, it says, this guarantee shall not be affected by any change in the time, manner, or place of payment or any other amendment of or any departure from the power purchase agreement.
Yes, Your Honor. So that language in the guarantee suggests that the obligations of the guarantor, here of Mars, Inc., will not change or be affected by any modification of the underlying contract, the PPA. So this guarantee refers to the PPA as the, quote, guaranteed document. It's a one-to-one relationship. Now, this was not the only guarantee between the parties. This is a complex wind farm deal for the development and production of renewable energy credits. And when they signed these contracts at the very beginning in 2014, there were actually 3 different guarantees. One for PPA 1, one for something called PPA 2, and one for something called the contract for differences. Each guarantee tied to a specific contract. So, Your Honor, the language you just pointed to says that the obligations on Mars, Inc., on the guarantor, will not change with modifications to the underlying agreement. Now, Justice Baroque below decided that what that language meant is that you don't need to decide the amendment question because Mars, Inc.'s obligations are fixed in time at the time they signed the guarantee. And on that ground, he dismissed the claim. But, Your Honor, you don't actually have to resolve that question. You can simply affirm on those grounds. But the majority of the panel's questions a moment ago were about the second ground. And that is just assume for argument that the PPA could be amended. The question then is whether the PBRMA is an amendment to that PPA agreement. And it is abundantly clear from the parties' contracts, from the text, and from New York law that it isn't. Now, my colleague here just said at the end of her statements that under New York law, what you look to is the effect of a document or a contract on another one to determine whether or not it's an amendment. And that's not quite right. You see, their argument is that this new contract changed the overall financial posture of the parties across all of these different agreements. And because it changed the economic effect on their overall relationship, well, that makes it an amendment. That's wrong for at least 2 reasons. One is if you go to those recitals in the PBRMA that the other side likes to rely on, they say, well, look, it says here that this mitigates Mars Wind's risk. That means because we intended it to mitigate risk, it must be an amendment. But the balance of that sentence actually references a different contract altogether and says that that contract also mitigates their risk under the BP hedge agreement. So if it's apples to apples, would this be an amendment of the BP agreement as well? Certainly not, but that's the same logic they're relying on. Second point, Your Honors, is what New York law actually says. And for this, I would direct you to the In re S.E. Nichols case, which I think has the best survey and statement of the standard. To be an amendment under New York law, you have to change, modify, delete, or remove a term of a prior agreement. Conversely, if a contract speaks to new subject matter or adds new obligations or new economic relationships, under New York law, it is not an amendment. So to Your Honor's questions, the PBRMA creates new obligations on both sides. Mars Wind agreed to accept certain of the production basis risk, that's the PB in the title, and in exchange for that, took on some additional financing based on a different sale of different pools of energy credits. That is the mutual consideration on both sides, those are the obligations on both sides, and they create a new contract. The PPA functioned the same before and after this contract went into place. It was calculated the same, invoiced the same, and functioned the same. So Your Honor should simply affirm the lower court's decision because the PBRMA is in no world an amendment to the PPA. If there are no further questions, we'll rest on our papers. Thank you.
Picking up on Your Honor's question about how that provision in the guarantee affects the, or applies, it's the provision in Section 5, Subpart 3. Well, it's Section 5, and then I'll focus on Subpart 3. It shall not be affected by, well, that's very similar language that we see in the Bankworms versus Andre Cafe Limited case that this court found was actually constituted an anticipatory agreement to consent to be applied, to be subject to modified obligations under a guarantee. And what the provision says is actually much more than what my colleague described. And you have to look at paragraph 5 of the guarantee in light of paragraph 3 of the guarantee. Paragraph 3 of the guarantee expressly waives a right to notice of modifications. Paragraph 5 goes beyond that. It actually says more. So paragraph 5 is a broad waiver, and in paragraph 5, the guarantor here, Mars Inc., waived not only notice of modifications, but also consent to modifications. And that's because the provision refers to any change in time, manner, or place of payment, or any amendment or waiver of, or any consent or departure from. And that has to mean more than just waiving notice of a modification, because that was already addressed in Section 3. So the Supreme Court's interpretation that Section 5 and Section 3 of the guarantee do nothing more than waive notice of a modification renders Section 5, Subpart 3 meaningless, and that violates basic contract interpretation principles. And as I said, this court has found similar language to be advanced consent to extend guaranteed obligations to amended obligations. And that's in the Bankworms case, which I just cited, where you see very similar language. In Bankworms, we also had an unconditional and irrevocable guarantee that also had continuing liability. And then this court's decision in Davamos versus Halley, which is cited in Justice Maisley's opinion in Sotheby's, hones in on that continuing liability piece and says that when someone agrees to continuing liability, that is an agreement to be obligated to guarantee amended obligations. Thank you.
Thank you. Thank you both. New York Civil Liberties versus New York City Department of Corrections.
Good afternoon, Your Honors. Alina Jerker on behalf of the Department of Corrections. Your Honors, the Supreme Court here made a mistake in construing the statute, and that decision at the outset prevented the court from going into the balancing that's required under FOIL when assessing the personal privacy exemption. So taking us back, what the court did, and I think the briefs read a little bit like ships passing in the wind. It seems like if you actually just read the court below's decision, it's quite clear that the court is finding that in the legislation that repealed 50A, the legislature has decided that unsubstantiated allegations against law enforcement officers are no longer covered by FOIL's personal privacy exemption. And
Well,
that's,
I don't think that's the case, but it seems like the city is relying on the privacy exemption to withhold, what's the word I'm looking for? But withhold completely the unsubstantiated allegations. And there is no complete bar anymore to unsubstantiated versus substantiated allegations. But that doesn't mean that an unsubstantiated obligation might not have something that meets the privacy exception that can be redacted.
absolutely. Just to clarify, the city has never taken, I mean, the city did very initially in this case take the position that it would be overly burdensome to redact, but that's not the position at all. The position is that there are 4 databases. 2 of them contain large narrative sections. So the Time Matters and the Service Desk, they have a thing. It'll say, Officer X touched me inappropriately on so-and-so day. And that will have inmate information, that will have information about the officer. And then that record will move through and there'll be additional sort of touches on that in the Time Matters record. And the city was saying, for us to go through, there are 20,000 entries in the service record. Go through, redact the officer's name, redact the inmate information, redact all of that stuff, and then go back to court and litigate whether or not those redactions are proper, and have an agency attorney do that twice doesn't make sense.
But just to touch on that subject, the city's, as you said, the city's position wasn't that you're not entitled to it. It's that it's going to take us too long to do it. It's burdensome. That's what the June 3rd letter said.
And so
and
initially,
then the Article 78 proceedings started.
Exactly, and then they said, and the parties both agreed, you can look at the reply in support of the petition that the NICLU submitted. They said, we agree. It would be incredibly burdensome to do all of that redacting before the court construes the repeal legislation and decides what the heck it means. Because there's open questions about how FOIL exists after the repeal of 50A, which had completely shielded these records. And how, for other public employees, if an allegation is made about a public employee, an improper something or another, and then they follow up and they say, well, actually, that employee wasn't even working that day. There's no probative value to that to the public, and so it's not disclosed under FOIL because there's a sort of the personal privacy of that public employee is sort of at its apex, and there's no public interest in knowing it.
I understand that, but that was, again, never disclosed, or that reasoning, that thought process, until after the Article 78.
So in the initial filing, so on May, the Department of Corrections put up a mass of records in March. Right after the repeal of 50A, all the city agencies started putting up lots and lots of information voluntarily. A month later, they submitted a FOIL request asking for every record that the department has, going back, I think possibly forever, but I could be wrong about that. And they submitted that to basically every law enforcement agency in New York State. So we said, give us a few days. We responded.
You said, give us 2 months.
So we responded, we said, give us 2
And then it took 5 months for the
then
Article
they sued.
78.
Then they said, on June 3rd, we said, we need 2 more months. On June 7th, we said, we take your request for more time as a constructive denial. We don't want you to continue. We want you to litigate this. I mean, it was clear that they wanted the legal question resolved. They didn't want us to go through and redact it. And everyone has sort of agreed from the start that what we want is this legal question resolved. And then the Supreme Court made a fundamental error in resolving that legal question, because if you read the decision, he says that the extent there's a conflict with FOIL is deemed that the amendment controls. But what he doesn't sort of grapple with at all is once 50A falls back, you have FOIL's pre-existing exemptions for personal privacy for public employees.
But then that brings us back to the documents that are able to be redacted, and I think that's what the Supreme Court said. We'll do in camera and redact what's not necessary, what's private.
But that's not what happened, because at that point, had the department gone and redacted. So I'd like to explain how the service desk matters work. It's like like a clearinghouse. So 311, any complaint the city gets from about a Department of Correction employee goes here. You get a little narrative. It says, officer did X on this day. It goes to the facility. Then the facility follows up. There's nothing in that record database that reflects what happened going forward with that. You know, whether the officer doesn't even exist, whether the officer didn't work that day, whether the officer doesn't work on that facility, or whether that was, you know, that went forward, was substantiated, went to the trial room, was prosecuted, and ended up in a guilty finding. None of that's there. And so an agency attorney is going to have to go through for every single one of those and follow through to figure out what happened to then apply those redactions. And all the agency attorney said was, can we just know for sure whether or not we're allowed to withhold the name and badge number about unsubstantiated allegations before we go through this process. And had we, if you look at Justice Frank's order, had we then gone through and spent 6 months doing those redactions, and he could have said in camera afterwards, no, actually, you can't have those. And that's what the forecast from his decision is. If you read that decision, it's on the record at 10. He says, the court finds, as petitioners contend, that if the legislature had intended to shield unsubstantiated records, it could have specified as such. So it left us in this place where we then, I mean, do we go and spend 6 months and like thousands of hours applying redactions to then have them removed? Or do we first confer with the court and ask, is this applicable? I see my time is up, so.
I have a question for you. With regard to, you said there's no, you know, you get the list of the unsubstantiated and you don't really know what the end result is. Where does the end result come out? Is there any database with the end result?
So there are 4 databases, one which was produced in total. And then the other 3 you can almost think of as stepping stones. So the first is this clearinghouse, which has 20,000 records. That one is going to be the most time-consuming to review because that's the one where everything goes into. After that, if the charge ends up in the Department of Investigation unit, then it's assigned a case number. It goes into the case management system. At that point, there's someone who investigates, and then it's either substantiated or unsubstantiated within that database. If it then goes forward further, and it's substantiated, then it goes to the trial, to oath for a trial, in which case it goes into the time management system. The time management system has an officer name. All of those records include only substantiated officers, but there are narrative sections, which include inmate names, officer personal addresses, all the names of the witnesses involved in the case, because it's a database for lawyers, basically, who are tracking a trial. So for each of those things, there's going to be extensive redactions in that portion, but not a withholding of the substantiated officers there. But in the first 2 databases, the service desk, which is the clearinghouse one, and the case management one, the names of the officers, their personal and their shield numbers, if the tracking, you know, if the person then confirms through paper files that this actually was unsubstantiated, those things then get redacted.
Okay, thank you. Let's hear from your opposing counsel.
Thank you.
Good afternoon, Your Honors. Bobby Hodgson for the New York Civil Liberties Union. I think it might help to state at first that this case is much simpler than the preceding argument would imply. And I do want to...
So tell me about the unsubstantiated. What happens with those? If you, let's say there's, you know, the officer's name in there and it's unsubstantiated, so they don't want to reveal that. What are you asking for in the unsubstantiated? I guess that's a better way to ask the question.
Certainly. All we're doing is asking this court to, number one, affirm what the court did below, which was not what the department has stated. We want the same FOIL process that should exist and has always existed, which is there is a presumption of disclosure, and then to the extent there is a specific reason to redact, a redaction can be proposed. They are asking for this court to...
I understand. To whole cloth, apply the privacy to unsubstantiated.
Well, not just... No, I actually do want to clarify this because they have abandoned the position that all material associated with unsubstantiated complaints can be withheld. They are conceding that they're going to turn over every one of these databases, and now they have narrowed this appeal to something that was not before the lower court. They're saying, oh, just on the issue of officer names, we would like a blanket rule allowing us to default, as a matter of law, consider those an invasion of privacy.
But doesn't the public officers law account for that, identifying information that can be excluded?
Respectfully, Your Honor, the amendments to the 2020 amendments to FOIL specifically name the name of the officer complained of or charged. This is Section 86, subsection 6. The definition of a newly created category of documents under the FOIA law enforcement disciplinary records, which are presumptively subject to disclosure, includes a list of things, complaints, allegations, any disposition, not just substantiated dispositions. And it specifically, explicitly says, the name of the officer complained of or charged. The name of the officer complained of. They are asking for a rule that would render that language meaningless by taking a different section of FOIL, the long-standing privacy exemption, and saying we can read that to, as a blanket matter, mean the name of the officer complained of is completely, redactable, and we can withhold it.
So
That is a
Supreme
rule that's
Court, so
inconsistent with the
Supreme
statute.
Court, so essentially, so Supreme Court rejected that argument, right? I
Yes.
mean, that's it. No, you got to turn it over. Then there were other issues that have to require in-camera. I mean,
Exactly.
Right? I mean,
It
that's
invited
exactly it, right?
just the process that the department is now
So if they
claiming.
want to go, if
if
they were looking for some sort of answer, Supreme Court gave them their answer. I mean, that's what you're telling me. They gave them their answer. You got to turn everything over.
Yes.
With respect to the unsubstantiated issues, the names got to be, you can't redact the names. That's it.
Yes, and if there is a specific instance supported by the facts of that case, as this court has always held, you can invoke the privacy exemption and say, in that specific instance, we want to redact.
All this is rising out of the 2020 amendment, right? I mean, this is like one of the fresh type of, I mean, this is like a trove of information that now you have with this amendment that you did not have prior to the amendment, right?
Yes.
That's it.
Let me just follow up with that. So in terms of the attorney's fees issue, right? They send a letter on June 3rd saying, hey, just give us 2 months, 4 days later, you send a letter saying that's constructively denying our request. In October, that's when the Article 78 is brought. Why would you be entitled to attorney's fees when it was just give us more time, not a denial?
Because their June letter asked for a specific amount of time. They said, we'll get it to you in August. And they had already had a previous deadline. We made the request back in April. They said, we'll get it to you in June. Before that due date, they said, oh, we're going to extend that to August. We said, we don't think that's reasonable. It's an electronic database. You need to start producing some things because it's pretty simple and we should talk about that.
But was her argument that, well, this has not really been interpreted by the courts, and why don't we just get the final answer before we spend all of this time, or either redacting or turning it over to you? Why don't we get a rule on it?
It is good to get a rule on it, but the fact that an agency has ignored a request, missed its own deadline, and forced us to sue to get them to engage in any negotiation is squarely addressed by
There's
this
a
court's
Fourth
precedent.
Department case that kind of says otherwise, that said because of a novel issue, it's not unreasonable for them to have taken that position.
But it wasn't a novel issue that they had to meet their own deadline or at least get back to us. We were forced to sue to even bring them to the table. So what the case law establishes is, yeah, we may have some reasonable disagreements down the line about certain things, but once we sued, they turned over thousands of documents.
Also, at the time that they requested the additional 2 months, had they turned over anything?
No, zero. And they had never even engaged in any...
When was the first time that any information was turned over?
After we filed the lawsuit, when they came to us and said, oh, let's figure out, because there's plenty of stuff we can give you. And they did.
And how did they turn that information over? Was it that they made it available on their website or electronically?
No, directly to us in response to our FOIL request because we sued them and they had ignored us previously.
And what did they turn over? What was it that they turned over?
They turned over one full database, including thousands of entries.
Unsubstantiated?
Well, based on that database, yes, it doesn't include any names, but it includes records of allegations and substantiated issues.
It's redacted, is what you're saying?
No, it's not redacted. There wasn't a column for that. So it was information about those. They turned over a second database that did fully withhold officer names. They turned over a series of explanatory documents, which was also what we had asked for, just saying, like, what databases do you have?
And in what kind of time period was that turned over, between the time that you brought suit and the time that you got that information?
Within a month, they turned over examples and several pieces of, obviously responsive material. And then we negotiated an amended schedule to narrow the issues for the court. But we were forced to sue to do anything.
Was the timing that when they did produce, would that have fallen within the 2 months that they requested?
Oh no, we sued long after the 2 months that they requested. We sued in October. They said they'd get back to us in August. Thank you.
Counsel, I have a question with regard to the attorney's fees and the amount of time. So counsel has indicated, and I'm just asking you, so you let me know your position, that once you were sued, you turned over a lot of information within a month, whereas when they asked for it in the first instance, nothing happened, even with the deadlines that you gave yourself.
As I understand it, the agency attorney first asked them for 5 days, then gave them the 2 months, then they said within 5 days of ARC, give us 2 months. That's a constructive denial. And then they sent a series of emails and letters saying, don't give us that. This is a denial. We want an appeal. Like, they did not want to have a conversation, is my understanding.
But you could have still turned, whatever you turned over within a month could have been turned over within all of that time before October. That's
So I agree that looking at it then, once the attention was put on it, that one database could be turned over without any conversation about the unsubstantiated records, because that one didn't reflect those. But the other three
so then
databases...
it could have been turned over even sooner than
So they should have
2
been able
months.
to turn it over even sooner, but that's
So
not a
then
basis
the way
for...
that this department has ruled in the past, they would be entitled to attorney's fees.
I don't believe so, Your Honor, but the attorney's fees are frankly like the secondary issue on the cross appeal. And most importantly is that the decision here made a decision about what the repeal legislation did to FOIL. And the idea that this was the city asking for a blanket exemption is just incorrect. So this was an undifferentiated a request for every document in the department's disclosure.
But what was the point of 50? What was the point of 50A being repealed, if not to say?
Thousands, millions of records were disclosed. First of all, the databases were placed online voluntarily.
But what my point is, why wouldn't they have just said, you know, we're not going to release it, instead of saying, well, it's released, but now all the unsubstantiated, you can redact all names from that.
What the legislature did
right across the board.
Removed there was an absolute bar on disclosing any record having to do with police discipline. Or, I'm sorry, law enforcement discipline. That was removed. That placed those employees in the same shoes as every other public employee in the state, which means that their records are presumptively public, but also that they are protected by personal privacy, public safety, and the other exemptions available in FOIL. So when my adversary refers to Section 86, which talks about how these things are now disclosable, that's absolutely true. They are disclosable, but they are still subject to potential exemptions from disclosure for privacy. So we would like to assert that exemption from disclosure for the unsubstantiated records that exist within the service desk. We want to be able to apply redactions to remove the names when that's not been substantiated. That's a very reasonable
So what you're asking
interpretation
for
of
is
the law.
in every case that is unsubstantiated, every case that's unsubstantiated, you want to be able to remove the name under the privacy exemption.
And the shield number in response to this request, because this request asks for every document under the sun. If you have an example, for example, some reason that there is a public interest, because there's not a probative value either for looking through into the system or for understanding anything to know the officers' names in this case. But let's say you say, this particular facility, this particular incident, this particular officer is a subject of heightened political or public scrutiny. We want to know everything about them, about that facility, or about officers who have more than a certain number of allegations. That's a different FOIL request than the one here. And there you have a balancing between the public's interest to know this information and what can be gleaned from it, and the privacy interest of the officer involved. But when we are talking about every single record of every single law enforcement officer, really in New York State across the board, then what you're just saying is that the exemption doesn't apply to this class of public employees. And if the legislature had intended that, it would say that. Because what it says instead, in the legislative history, all the people speaking, and it's in the record, they say, we're putting them in the same shoes as everyone else. This will lead to the release of some unsubstantiated records for sure, but also there will still be protections for these officers. And the position that the NICLU is taking, that they don't exist whatsoever. And for all those reasons, our position was reasonable from the start. And that's why they're not entitled to attorney's fees. Well,
this issue. That was not your position from the start. That wasn't even, in fact, your position 1 month into the Article 78 because you turned over documents.
Well, it was the position. They said they didn't say we're going to withhold all records across the board 100%. They said some of these records are subject to non-disclosure. right? So if someone asks for a FOIL request and we go and we produce everything that we possibly can, and then we spend hours redacting them, and then they bring the Article 78. This is in an area of law where no one really knows what's going on. Then they bring the Article 78, and then we have to remove all those redactions
Counsel, why not produce what you could produce? Why not produce what's not in debate?
I absolutely agree with you. It would have been the better course. I mean, there probably could have been a better way to do it, but frankly, they were getting a flurry of requests. The 50A had just been repealed. They just made a public database. This is not the only request they have. It's a very small team, and they did what they could, and they probably could have done it a little faster. But they did not just outright deny this with no reasonable basis. They said, this is a really complicated legal question. I don't quite know what to do. And they put it to the court, and now the court is in a position to answer it. And then they will do all of those redactions in good faith. I believe that the amendment to FOIL that makes attorney's fees compulsory was meant to address a very different kind of situation where, for no good faith, they just sit on requests and don't do anything. And that's just not what happened here.
Thank you.
Thank you.
Hang on.
Your Honors, very quickly, I want to move on from the fees issue as well, because I think the really important thing here is the merits of this and what they are asking this court to do, which no other court has done, create this blanket rule. And to be clear, before the lower court, they were saying not just names, all unsubstantiated material from the date to the allegation, et cetera, is completely out of bounds. And the court rightly rejected that. That needs to be affirmed. On this issue, they are saying, we want to flip the burden. We are conceding that in certain cases it's absolutely appropriate to turn over the name associated with an unsubstantiated complaint, but we're saying, oh, a plaintiff needs to prove that up. That's not how FOIL works. The burden is on the department on a case-by-case basis to show that redaction is appropriate. And here, they've conceded this. They released tens of thousands of similarly situated names in the context of a giant CCRB database that tracks unsubstantiated and substantiated complaints associated with NYPD officers. They've conceded that for DOC officers, the very DOC officers whose names show up—
So how do you respond to the proposition that redactions are dependent on the purpose for what the information is being sought?
I mean, there is a balancing test that says what is the public's interest in this versus what is the potential invasion of privacy. But again, the burden is always on the defendant to show that the privacy invasion overwhelms the public interest. Here, there's a giant public interest in making sure these databases are complete. You can see, for example, whether a person is the subject of 90 complaints that went uninvestigated or 1, whether a person's name shows up on the 4 different seemingly incompatible databases that the DOC may or may not be using correctly to track some of these complaints. This is a matter of very public and very current interest about how is the department itself tracking investigations.
But based on what I'm hearing, all this trove of information is all coming at you fast now. I mean, you've got like information that you never had before 2020, right? I mean, this is something this amendment opens up the door. It's transparency 101.
That was the point of it.
Right.
It has been disappointingly not fast, and it hasn't been
Not so
turned
bad, but this is where we're at. So
Yes.
what I'm saying is at some point the agencies have they have to change their MO because they were all pre-2020 where they had ingrained in them no. But now it's got to be the other way around, right?
Yes, and the law requires that.
Yeah, I'm not.
Oh no, I
arguing
agree
with
with
that
Your
point.
Honor.
I'm just saying that this is all, whatever it's worth, is sort of uncharted territory a little bit. Correct?
It is.
It's like the presumption is everything is discoverable, and you have to show that it should be redacted. That's what the city has to come in and say in camera it has to be redacted. It's on them now, not the other way around. It used to be the other way around.
It used to be they couldn't. Yes, they couldn't touch it at all.
You couldn't get it right.
Yes, but
But if you did get something in the old days, you would have to say you should unredact it.
Exactly.
Okay.
Thank you, Your Honors.
Thank you. Thank you both.